And to that piece of lieutenant that's always on his podcast, bash us, him.
Plaintiff against complaint. Docket number. City of New York, Eric Adams, Tanya Kinsella, individually. Jeffrey Madry, individually. John Chell, individually. Kaz Daughtry, individually. Tarek Shepard, individually. Michael Gerber, individually. Paul Saraceno, individually. And Anthony Marino, individually. Defendants. Plaintiff Thomas G. Donlon, by his attorneys, Law Office of John A. Scola, PLLC, complaining of the defendants respectfully as follows. Preliminary statement. 1. The New York City Police Department, under the direction of Defendant Adams, functions as a racketeering enterprise in violation of the Racketeer Influenced and Corrupt Organizations Act, 18 U.S.C. SS 1961 ET Sec. Senior leadership had abandoned lawful governance and engaged in outright malfeasance by using the NYPD to consolidate political power, obstruct justice, and punish dissent. 2. A coordinated criminal conspiracy had taken root at the highest levels of city government, carried out through wire fraud, mail fraud, honest services fraud, obstruction of justice, and retaliation against whistleblowers. This enterprise, the NYPD, was criminal at its core. The defendants engaged in a coordinated pattern of racketeering activity that was deliberate, sustained, and directed from the highest levels of the NYPD and City Hall. As detailed throughout this complaint, the defendants obstructed justice in violation of 18 U.S.C. SS 1503 by sabotaging internal oversight efforts, canceling Donlon's meetings, altering his schedule, spying on his communications, and systematically excluding him from operational decisions. 3. They manipulated the Internal Affairs Bureau to prevent disciplinary referrals and block investigations into executive misconduct. The defendants used Donlon's official police commissioner stamp without authorization to forge internal documents that were then used to promote unqualified, politically connected officers over those who had earned advancement through merit. This corruption triggered a massive, unlawful transfer of public wealth, millions of dollars in unearned salary increases, overtime eligibility, pension enhancements, and post-retirement benefits. The defendants committed wire and mail fraud under SSSS 1341 and 1003. 143 by disseminating materially false information through official city systems, including promotional lists and internal communications. They engaged in honest services fraud under SS 1346 by subverting the promotion process, trading public trust for loyalty, silence, and political protection. And they retaliated against whistleblower Thomas G. Donlon in violation of SS 1513 by dismantling his authority, orchestrating his removal, and targeting his wife with unlawful arrest and defamatory leaks. 4. These predicate acts were not isolated. They were coordinated and systemic, forming an unlawful scheme to preserve power, punish dissent, and defraud the public. As part of the relief sought, plaintiff demands the appointment of an independent federal monitor with full authority to oversee and report on NYPD disciplinary processes, whistleblower protections, and promotion decisions to ensure compliance with law and prevent further abuse. 5. Defendant Adams publicly appointed plaintiff Thomas G. Donlon, a distinguished former senior executive in the Federal Bureau of Investigation, as interim police commissioner amid a wave of criminal investigations targeting his administration. 6. But the appointment was illusory. In reality, Donlon was commissioner in name only. True authority remained with defendant Adams's corrupt inner circle. Defendant's first deputy commissioner, Tanya Kinsella, chief of department, Jeffrey Madry, chief of patrol, John Chell, Deputy Commissioner Kaz Daughtry, Deputy Commissioner of Public Information Tarek Shepard, and Deputy Commissioner of Legal Matters Michael Gerber. 7. These individuals exercised unchecked power while Donlon was sidelined and used as a public relations shield. The defendants undermined Donlon's authority by blocking his merit-based promotions, and instead elevating unvetted individuals of their choosing. The defendants then fraudulently used Donlon's official police commissioner stamp, without his consent, to legitimize and carry out their corrupt scheme. 8. Upon assuming his position, Donlon quickly uncovered systemic corruption and criminal conduct being perpetrated by the NYPD's executive leadership. He reported these findings directly to Defendant Adams. 9. Specifically, Donlon informed Defendant Adams of fabricated promotions, systemic fraud, retaliatory policing, and the obstruction of internal investigations by high-ranking officials, most notably Defendant Shepard, who had a documented history of unlawful violence including the tasering and false arrest of protesters, resulting in civil rights lawsuits and monetary settlements. Defendant Adams took no action in response. Instead, he condoned the misconduct and allowed the NYPD to function as a criminal enterprise. 10. As a direct result of Defendant Adams's failure and unwillingness to manage the NYPD, Defendant Shepard fraudulently orchestrated his own promotion, granting himself greater authority and a higher salary. 11. Donlon confronted Defendant Shepard directly, denouncing the act as stolen valor, but the rebuke had no deterrent effect. When Donlon demanded accountability for the NYPD defendants' collective misconduct, they turned against him. He was frozen out of operational and administrative decisions, stripped of real authority, and ultimately removed from his role as interim police commissioner in retaliation for his internal complaints to Defendant Adams concerning the corruption, dereliction of duty, and criminal misconduct he had witnessed. 12. From the outset, Donlon's mission was clear: to protect and guide the honest rank-and-file officers and supervisors who had been abandoned by a leadership class rotting from the top. 13. He sought to restore integrity, raise morale, and defend those who risked their lives daily to protect and serve. These officers had been betrayed by corrupt high-level executives and a mayor more interested in political loyalty than public safety. Donlon tried to be that leader. For this, he was unlawfully targeted. 14. The retaliation extended beyond professional consequences. In a calculated and deeply personal act of vengeance, Defendants Daughtry, Shepard, and Gerber orchestrated the false arrest and unlawful detention of Donlon. His wife, Mrs. Deirdre O'Connor Donlon, a private citizen with no connection to his official duties, by NYPD officers under their control. This was not a mistake. It was a deliberate abuse of power designed to punish and intimidate Donlon for exposing their misconduct. Mrs. Donlon O'Connor was handcuffed behind her back, subjected to a full body and personal effects search at the 17th Precinct, and told by Officer Vargas that she would be transported to central booking. This coordinated humiliation was a direct warning. The NYPD defendants would stop at nothing to silence and personally destroy Donlon, even if it meant violating the constitutional rights of his spouse. 15. Donlon receives press calls within minutes of his wife's release. Donlon received a call on his personal cell phone from a New York Post reporter asking for comment, followed by a call to Mrs. Donlon O'Connor. The source of the leak was soon revealed. The Office of the Deputy Commissioner for Public Information, led by Defendant Shepard, had disseminated the Donlons' personal phone numbers and intimate family details to the press. By 11:06 p.m., a vicious and factually incorrect article was published, complete with home addresses, dates of birth, and other private information, syndicated across multiple media outlets. This malicious media leak could only have come from inside the NYPD. Despite the egregious abuse of authority and the widespread coverage it generated, neither Defendant Adams nor Police Commissioner Tisch ever contacted Donlon or his wife to explain or apologize. For Donlon and his wife, who have always held the NYPD in the highest regard, this incident marked a devastating betrayal by a department they once trusted. 16. Collectively, these acts: unlawful arrest, unauthorized disclosure of private data, obstruction of internal probes, and a leadership that rewards silence, comprise a pattern of racketeering under RICO. In collusion with Defendant Adams's office and NYPD command, promotions and favors were allegedly traded to suppress dissent and bury accountability. It was known that this matter was discussed with the mayor and his administration, and also by the NYPD police commissioner, but no contact was made with Donlon or his wife. 17. The defendants leveraged governmental authority and infrastructure to commit crimes, cover up misconduct, and retaliate against internal dissenters. Their conduct meets the legal definition of a RICO enterprise, an association in fact engaged in a pattern of racketeering activity through public channels. 18. With New York City and NYPD under the control of Defendants Adams and Madry respectively, promotions were traded for silence, investigations were obstructed, dissent was punished, accountability was buried. 19. As a direct and proximate result of these RICO violations by all the defendants, Donlon suffered extensive financial harm. He lost his income, pension eligibility, and career prospects, both in the law enforcement intelligence communities, along with private and public sector positions. His professional reputation, built over decades of federal and state law enforcement and intelligence service, was deliberately destroyed. The emotional toll of the retaliation against his entire family was and is incalculable. These were precisely the kinds of injuries RICO was designed to remedy, and this complaint seeks redress for Donlon, whose unwavering aspiration from the beginning was to protect and serve the NYPD's finest. Table of contents. Heading. Causes of action. Jurisdiction. 20. This action is brought pursuant to 42 U.S.C. SS 1983 and 1988, and the First Amendment and 14th Amendment to the United States Constitution. 21. This court has supplemental jurisdiction over plaintiffs' related claims arising under state and local law pursuant to 28 U.S.C. SS 1367. 22. Jurisdiction is founded upon 28 U.S.C. SSS 1331 and 1343. Venue. 23. Venue is properly assigned. U.S. District Court for the Southern District of New York under 28 U.S.C. SS 1391, in that this is the district in which the claim arose. Jury demand. 24. Plaintiff respectfully demands a trial by jury of all issues in this matter pursuant to Fed. R.C. of P38. Parties. 25. Plaintiff Thomas G. Donlon is a resident of New York City, New York. 26. Donlon began his distinguished public service career in October 1981 when he was appointed as a special agent with the FBI. 27. During his tenure with the FBI, Donlon held a high-level national security role at FBI headquarters, located in Washington, D.C., last serving as Section Chief, National Threat Center Section, Washington, D.C. Top 1%, and prior to this executive position, Assistant Special Agent in Charge, Counterterrorism Division, Joint Terrorism Task Force, New York Office, Coordinating Supervisory Special Agent, NYO, CTD, and SSA, CTD, NYO International and Domestic Terrorism, Supervisory Special Agent, CTD, NYO. 28. SSA, assigned to the Violent Crime Section, Safe Streets Unit, FBI HQ, Washington, D.C. In this role, Donlon was responsible for the northeast section of the nation, specifically New York City, which was and still remains a critical intelligence hub for evaluating and responding to domestic and international violent crimes. 29. While assigned to JTTF, NYO, Donlon closely worked with all the JTTF agencies, primarily in conjunction with the NYPD, coordination and investigation of some of the most critical and high-profile terrorism cases in the USA and abroad. While assigned to the JTTF, Donlon interacted with approximately 43 federal, state, and city law enforcement and intelligence agencies assigned to the JTTF, NYO. 30. Donlon served as a co-case special agent on the Manila Air case before transferring to FBI HQ, a widely known and publicized case of the NYO JTTF, alongside Special Agent Francis J. Pellegrino. This case revolved around Project Bojinka, a plot masterminded by Ramzi Youssef and his co-conspirator Abdul Hakim Murad, intending to simultaneously bomb 11 U.S. airliners while en route over the Pacific Ocean. 31. Donlon and Pellegrino, along with the SDNY prosecutors, successfully secured and extradited Murad from the Philippines. While en route to the USA, Pellegrino and Donlon obtained a confession in which Murad not only implicated himself, but also Youssef. Moreover, Murad provided specific details of Project Bojinka. At the time of Murad's extradition, Youssef fled to Pakistan, where he was captured months later. Both were ultimately convicted for their roles in the Project Bojinka plot. 32. Donlon, while assigned as Section Chief, NTCS, played a foundational role in developing the FBI's Guardian software database, now known simply as eGuardian, which was the FBI's first centralized counterterrorism database still used today by U.S. federal, state, and local law and intelligence agencies nationwide. Donlon's NTCS initiated CT Watch Unit, also initiated and managed the FBI's terrorism watch list, one of the most sensitive and consequential responsibilities in federal law enforcement. Donlon, with the NTCS personnel, created the Guardian system after discovering, in the aftermath of the 9/11 attacks, there was no unified database which captured all domestic and international threats. The system was designed to enable the FBI, JTTF, and other federal, state, local law enforcement, and intelligence agencies nationwide to input and access threat information relevant to their jurisdictions. This is an example of the nationwide FBI sharing information with all members' agencies, but also with other federal, state, and local agencies not assigned to the JTTF nationwide. The database has remained in operation and continues to be a critical tool in the successful apprehension of terrorists, contributing to hundreds of arrests and terrorism investigations. 33. Donlon served as the co-case special agent in the aftermath of the February 1993 World Trade Center bombing, the first time a terrorist attack was perpetrated by radicalized Islamic terrorists on U.S. soil. The investigation resulted in 5 federal convictions and reshaped the nation's approach to international terrorism. 34. After retiring from the FBI in 2005, Donlon served as Global Security Director for two major financial institutions, applying his expertise to protect critical infrastructure from emerging threats. 35. In 2009, Donlon was appointed by then New York State Governor David Paterson to serve as Director of the NYS Office of Homeland Security. In that role, Donlon oversaw statewide emergency preparedness and counterterrorism initiatives, distributing funding to police departments, fire departments, first responders, emergency medical units, offices of emergency management, and other public safety agencies to improve response efforts for both natural and human-made disasters. The distribution of these funds by NYS Homeland Security were disseminated pursuant to the submission and review of applications filed by the above state entities who were in desperate need of funding to protect and serve their respective communities. 36. Furthermore, Donlon was responsible for disseminating millions of dollars in NYS funding, including critical funding for the initial establishment of the Lower Manhattan Security Initiative. After Donlon was named as the NYPD Interim Police Commissioner, then Sanitation Commissioner Tisch, who previously worked in the NYPD Information and Technology Bureau, attended a joint NYPD Sanitation Department press conference with Donlon regarding the Ghost Plate investigation. Before the press conference, a grateful Tisch stated to Donlon, "Without your NYS funding, we would have been unable to establish the LMSI." Donlon thanked Tisch and was very appreciative of her kind words. Donlon expressed his long career working relationship with the NYPD and JTTF and his utmost respect and honor working with past and present JTTF members. Adams is well aware of this NYS funding provided to the NYPD, as Adams was a NYS senator and then chairman of Homeland Security representing NYS senators at the time of the financial distribution to the NYPD. 37. Donlon exercised broad discretion over the allocation of these funds, including directing monies not only to the NYPD, but also to the FDNY, EMTs, NYCOM, first responders, etc., to bolster their terrorism concerns, first responder equipment, public safety capabilities, along with the overall distributions of NYS funds to the other NYS-wide agencies, as described above. 38. Shortly before the press conference, Donlon would be appointed and employed by the NYPD in the defendant city of New York as Interim Police Commissioner from September 13, 2024, through November 24, 2024. After his removal as Interim Police Commissioner, Donlon was assigned to the role of Senior Advisor, Office of Public Safety, under Defendant Adams. 39. On April 25, 2025, Donlon was notified by a human resource employee assigned to the mayor's office that Donlon's last day as senior advisor would be May 9, 2025. When Donlon inquired as to the reason for said termination, Donlon was advised by the HR individual his senior advisor position is being eliminated. Donlon inquired as to the reason, and no explanation was provided to Donlon. Donlon further asked for documentation to be provided and was told by the above HR person no documentation will be provided to him. Donlon was told that Adams' office, as mentioned before, has eliminated his position as the senior advisor. This position involved closely working and coordinating with the public safety agencies. The duties and responsibilities encompassed assisting the agencies with their direct submission of applications seeking available funding from the U.S. federal and NYS grant programs. Donlon and James Gunn produced a first-ever booklet outlining the entire application process, along with the numerous links and names of the available funding to the above public agencies. It should be noted the submission of the agency's applications would be individually submitted by them, along with their own research. As set forth throughout this complaint, Donlon's abrupt and unexplained termination was not a legitimate personnel decision. It was a clear act of retaliation. 40. Donlon's service as Interim Police Commissioner was done amidst a daily and constant onslaught of personal attacks and professional sabotage committed by the indignant, inexperienced, and insubordination of the NYPD top executives making critical decisions which defied logic, common decency, and professionalism. Moreover, the shocking display of immorality and indecency by the collective defendants, Adams, Kinsella, Madry, Chell, Daughtry, Shepard, Saraceno, and Marino, was an affront to the core moral and professional values always demonstrated by Commissioner Donlon. 41. The collective conduct of the defendants was nothing short of deliberate acts of resistance and corruption. Donlon did not remain to serve these corrupt and power-hungry individuals, but rather to support the dedicated men and women of the NYPD who were being systematically neglected by their superiors' incompetence, hypocrisy, corruption, self-interest, and abusive exercise of authority. Donlon stayed not out of self-interest, but out of duty to expose and combat the rampant corruption and destructive leadership that threatened to dismantle the greatest police force in the world. Donlon was driven by a moral imperative to protect those who truly uphold the oath to serve, not to be served. 42. Donlon's commitment to the NYPD was rooted in something far deeper than professional obligation. As a boy, Donlon walked the halls of many precincts with his father, who worked for the NYPD as a carpenter, assigned to the Building and Repair Bureau. Donlon's father would usher him into station houses and say, "I want you to meet good people." These early encounters with police officers, detectives, supervisors, and all NYPD personnel helped shape Donlon as he witnessed the officers' quietly radiating purpose. Donlon saw not just uniforms, but humanity. That legacy became his compass, and decades later, it was the same clarity of purpose which anchored him in office amid chaos, a word Defendant Adams frequently used describing Donlon's interaction with defendants. Donlon stayed not for power, self-aggrandizement, but to honor the institution his father revered, to stand with the good people who still believed in the badge, and to resist those who sought to destroy it from within. The main objective of Donlon was to serve all the NYPD members of service, not those in executive positions who abused their authority and public trust with the support and protection of Defendant Adams. 43. Defendant City of New York is a municipal corporation organized under the laws of the state of New York. The city maintains and oversees the NYPD, a duly authorized law enforcement agency, as well as the Department of Citywide Administrative Services, which includes employment structures related to the Office of Public Safety. 44. Defendant Eric Adams was, at all relevant times, the mayor of the city of New York. Adams possessed final policymaking and operational authority with respect to all New York City government agencies, to include, in particular, the NYPD and Defendant City. 45. Defendant Tanya Kinsella was, at all relevant times, the NYPD's first deputy commissioner. 46. Defendant Jeffrey Madry was, at all relevant times, the NYPD's chief of department. 47. Defendant John Schell was, at all relevant times, the NYPD's chief of patrol. He was later promoted to chief of department following Donlon's departure as police commissioner. 48. Defendant Kaz Daughtry was, at all relevant times, either the NYPD's deputy commissioner of operations or, then, was promoted by Defendant Adams to the deputy mayor of public safety after Donlon departed as police commissioner. 49. Defendant Tarek Shepard was, at all relevant times, the NYPD's deputy commissioner of public information, an assistant chief, and temporary chief of staff to the police commissioner. The latter titled Defendant Shepard fraudulently promoted himself by unlawfully using Donlon's official police commissioner rubber stamp signature and sending the memo to the NYPD chief of personnel. 50. Upon information and belief, Defendant Marino provided said rubber stamp signature to Defendant Shepard. Per NYPD rules and protocol, only the person serving as the deputy chief in the office of the police commissioner has sole control, as also advised by Defendant Marino to Donlon, possession and authority to utilize said rubber stamp signature with, of course, consultation with the police commissioner. 51. Defendant Michael Gerber was, at all relevant times, the NYPD's deputy commissioner of legal matters. 52. Defendant Paul Saraceno was, at all relevant times, an inspector or deputy chief in the NYPD. The latter title was conferred upon Defendant Saraceno by Defendant Madry immediately after Donlon's departure from the NYPD. Furthermore, and for clarity, Defendant Saraceno had already been forced to retire in 2022 for an egregious disciplinary matter by NYPD executives, Internal Affairs Bureau. After over 1 year in retirement, as advised by Defendant Saraceno, Defendant Madry offered Defendant Saraceno an opportunity to return to the NYPD as an inspector, his final level upon retirement, to serve under Defendant Madry as his chief of staff. 53. Defendant Madry's administrative decision to reinstate Defendant Saraceno to his last position after his forced retirement and disciplinary record was unprecedented, as advised by NYPD executives. Additionally, Defendant Madry violated all NYPD policies, protocols, procedures, and code of conduct, and likely federal and state law, in fraudulently promoting Defendant Saraceno to deputy chief under new police commissioner Tisch. 54. Curiously, Defendant Madry emphatically advised Donlon in front of MOS, specifically Defendants Kinsella and Marino, that while reviewing and selecting MOS for promotions, he always takes these promotions very seriously. Defendant Madry advised Donlon that he conducts a proper and thorough review of his proposed promoted past and recent performances before rendering a final decision. It should be noted from a prior review of Defendant Madry's promotions by Donlon, it was quite obvious that Defendant Madry did not promote MOS based on performance. 55. Defendant Anthony Marino was, at all relevant times, a deputy chief in the NYPD, assigned to the police commissioner's office. After Donlon's departure, Marino was assigned to the NYPD Detective Bureau. 56. At all relevant times, the above defendants, either personally or through the people who reported to them, acted under color of state, law, and in accordance with the policies, customs, and practices of the City of New York and the State of New York. 57. All acts alleged herein were undertaken by the defendants, including the many illegal acts, were performed while employed and with the direct knowledge of the City of New York. 1. Basis for racketeering influence and corrupt organization. ACT 18 USC SS 1961 ED Sec. Claims: A. Racketeering scheme within the NYPD and City Hall. 58. Donlon witnessed firsthand a racketeering enterprise operating within the NYPD and City Hall. This criminal enterprise was orchestrated by high-ranking officials, including defendants City, Adams, Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino, each of whom occupied senior command positions within the NYPD. These individuals acted in concert and under the protection and direction of Defendant Adams, using their official positions to engage in a pattern of fraud, retaliation, obstruction, and abuse of power in furtherance of their criminal enterprise. 59. This enterprise was not haphazard. It was deliberate, hierarchical, and ongoing. Its core function was to shield loyalists and silence internal critics through a calculated regime of favoritism, retaliation, and concealment. Promotions and assignments were manipulated to reward obedience rather than merit. Misconduct was buried rather than addressed. Time and again, Donlon raised alarms about rampant corruption, fraudulent promotions, stolen valor, false public messaging, and internal retaliation. Rather than investigate, the enterprise moved against him with surgical precision, stripping his authority, systematically excluding him from core decision-making processes, continually and consistently lying to Donlon, and ultimately eliminating his police commissioner position. Donlon's integrity was viewed as a threat, and the enterprise responded accordingly. 60. The predicate acts of racketeering included wire fraud, mail fraud, obstruction of justice, whistleblower retaliation, and honest services fraud, all carried out under the guise of legitimate governance. These acts were not isolated, but were committed as part of a coordinated scheme to defraud the public, suppress the truth, and punish those, like Donlon, after Donlon refused to acquiesce to the corruption. Public resources, government infrastructure, and electronic communications were weaponized to serve the enterprise's unlawful goals. 61. The enterprise engaged in a closed-ended pattern of racketeering over a substantial period, with the same actors participating in multiple related acts of misconduct. It also presents an open-ended threat to public integrity, as these same tactics continue to be deployed against internal critics. Donlon's career was not simply derailed, it was deliberately destroyed. His position unjustly eliminated, as stated by HR. His reputation systematically tarnished, and his decades-long career in law enforcement and intelligence communities in the private and public sector extinguished in retaliation for one simple act: refusing to participate in fraud. That destruction constitutes injury to business and property under RICO. B. Overview of RICO claims. 62. Defendants City, Adams, Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino, acting in concert and under Defendant Adams' protection, formed an association, in fact enterprise, with the purpose of consolidating power, retaliating against whistleblowers, concealing misconduct within the NYPD, and distributing public appointments, promotions, and authority as political rewards. 63. The enterprise operated within the City of New York and engaged in interstate commerce through the use of electronic communications, federal funds, wire transfers, and the misuse of public infrastructure. It was continuous, coordinated, and driven by the shared objective to preserve influence, punish dissent, and shield members from scrutiny and accountability. 64. This enterprise failed to merely preserve political power. It became a vehicle for personal enrichment. Senior officials both in the NYPD and mayor's office used their control over public appointments, discretionary promotions, permanent promotions, and law enforcement contracts to reward allies, secure loyalty, and extract financial gain for themselves and their friends and associates. Promotions that should have been earned through merit and civil service testing were instead knowingly criminally provided as political favors, resulting in unearned raises, inflated pensions, and enhanced access to overtime and benefits with absolutely no NYPD oversight. The value of these illicit promotions ran into the millions of dollars. Bluntly, public funds were misappropriated for private benefit. 65. Regrettably, the officers whose names and ranks Donlon approved and forwarded on 3 separate promotion lists were systematically removed without his knowledge or consent by defendants Madry, Shepard, Marino, and most disturbingly, with the approval of defendant Adams. The men and women whom Donlon recognized and approved for promotion had earned their promotions through tireless dedication, protecting the public, saving lives, solving complex cases, making critical arrests, and preventing future crimes. Yet their hard-won recognition was callously discarded by defendant Adams and the NYPD defendants. 66. The members of service whose names were approved and forwarded by Donlon for promotion, based on their consistent dedication, life-saving actions, successful arrests, and crime prevention efforts, were deliberately discarded and excluded by defendant Adams and the individual defendants. Despite being fully aware of the misconduct and injustice committed against these officers, neither defendant Adams nor Police Commissioner Tisch has taken any steps to remedy this gross abuse of power. These deliberate and deceitful acts not only harm the MOS professionally, but also cause significant financial and emotional harm to them and their families. The officers lost salary increases, enhanced pension benefits, and future advancement opportunities within the NYPD. When Donlon later spoke with several of the impacted officers, he learned that beyond the financial damage, the emotional toll was profound. These officers, who once took great pride in their service and believed in the integrity of the department, felt betrayed, demoralized, and diminished as they watched their rightful promotions stolen and handed to politically connected individuals who had not earned the recognition. 67. What compounds this injustice is that defendant Adams, the collective NYPD defendants, and current Police Commissioner Tisch's administration are fully aware of this injustice, yet have done nothing to correct it. Upon information and belief, defendant Adams confessed privately to unidentified colleagues that he recognized the wrongdoing and intended to make good on these promotions. No action by defendant Adams has occurred, nor most likely will it ever. Donlon himself informed defendant Adams via email and in person that his, Donlon's, proposed promotions had been dismissed specifically by defendants Madry and Shepard. The officers recognized by Donlon have had their careers stunted without explanation or recourse. 68. The consequences of this fraud committed by defendant Adams and the collective NYPD defendants extends far beyond wounded pride and loss of self-esteem. These officers and their families face real financial losses. Their higher salaries, enhanced pensions, future promotional opportunities were all tragically lost because of deliberate concealment, dishonesty, and fraud committed by the defendants. Yet, the deepest wound is emotional. These forgotten officers took immense pride in their work, investing countless hours in investigations, community initiatives, and public safety. To have that dedication first acknowledged by Donlon and unmentioned honorable NYPD executives, and then so abruptly stripped away, is a betrayal that hurts and torments them daily. 69. Despite repeated public assurances from defendant Adams, current Police Commissioner Tisch, and other senior NYPD leaders that they stand firmly against injustice and champion the NYPD's finest, their inaction on this issue speaks louder than any pledge. If they truly cared for the men and women who serve this city, they would immediately restore the promotions these officers earned. Leadership demands more than rhetoric. It requires courage to right a profound wrong. The time has come for our city's leaders to deliver on their promises, correct this grave injustice, and honor the commitment of those who have faithfully protected New York's 5 boroughs. 70. Upon information and belief, the enterprise further exploited confidential city data, U.S. federal and New York state grant funding, and municipal procurement processes to steer contracts and public resources to individuals and entities aligned with defendant Adams's inner circle. Public reports and investigative findings have revealed that close allies of the mayor, including Tim Pearson and Philip Banks, have come under federal scrutiny for schemes involving contract fraud, kickbacks, and protection payments. These were not isolated incidents. They were components of a broader systemic pattern of corruption coordinated from within City Hall. 71. Upon information and belief, the enterprise also manipulated federally funded overtime systems by deliberately entering false or misleading grant codes to divert U.S. Department of Homeland Security and Department of Justice funds to officers favored by the mayor's political allies. This fraudulent coding scheme allowed defendants to siphon federal grant money in real time, rewarding loyalty with illicit overtime and distorting official deployment records. rather than allocate federal resources based on operational need or lawful criteria. The enterprise used the NYPD's internal timekeeping and grant reimbursement systems as a vehicle for political patronage and personal enrichment. This abuse of federal funding mechanisms represents not only theft of public funds, but a deliberate subversion of the safeguards intended to prevent precisely this kind of corruption. 72. This deliberate misuse of municipal power, public funding, and law enforcement authority for personal enrichment and political favoritism constitutes racketeering activity within the meaning of RICO. The conduct described herein reflects an ongoing criminal enterprise operating under color of law with City Hall and NYPD infrastructure weaponized to advance the financial interests and political agendas of Defendant Adams and his associates. 73. While the full scope of Banks's and Pearson's criminal activity is not yet known, Donlon personally witnessed multiple RICO predicate acts committed by the named defendants during his tenure at the NYPD. 74. The defendants' racketeering acts include, but are not limited to, wire and mail fraud, dissemination of materially false information about public safety appointments, promotional qualifications, internal investigations, and official communications, all designed to deceive the public and consolidate power, retaliation against a witness or informant, systematic dismantling of Donlon's authority, exclusion from operational decision-making, and elimination of his position, all in direct retaliation for his whistleblowing, obstruction of justice, concealment or destruction of incriminating evidence, intimidation of potential witnesses, and fabrication of pretexts to justify adverse employment actions against Donlon and others, bribery and honest services fraud, granting of unearned promotions, favored assignments, and other benefits to individuals who supported or ignored the enterprise's illegal conduct, trading public trust for silence and loyalty. 75. The full extent of contract bid rigging and illegal contracting by the defendants is yet to be uncovered, but upon information and belief, further violations of federal law are ongoing and will be added as they are discovered by the FBI. 76. These actions were not random, nor were they aberrational. They constitute a sustained and systemic pattern of criminal conduct that continues to threaten public safety and institutional integrity. The enterprise still operates, silencing dissenters, manipulating public trust, and obstructing justice with impunity. 77. As a direct and proximate result of the defendant's racketeering, Donlon suffered severe harm. He lost his income, career trajectory, and pension eligibility. His professional reputation, built over decades, was irreparably harmed. These injuries represent a concrete loss of business and property under 18 U.S.C. SS 1964, entitling Donlon to treble damages, attorney's fees, and all other relief available under law. C. Overview of RICO conspiracy. 78. Defendants City, Adams, Kinsella, Madry, Schell, Daughtry, Shepard, Gerber, Saraceno, and Marino, along with others known and unknown, knowingly and willfully conspired to violate 18 U.S.C. SS 1962 by agreeing to conduct and participate, directly and indirectly, in the affairs of an enterprise through a pattern of racketeering activity. 79. Each defendant knowingly aligned with the enterprise's central purpose to consolidate political power, shield misconduct, suppress dissent, criminally misuse U.S. federal funds, and exploit public authority for private and political gain. This was not a passive association. Each defendant took active steps to further the conspiracy, including 1. Disseminating fraudulent communications and executing retaliatory employment decisions, and fraudulently promoting NYPD officers through forgery, obstructing internal investigations, and 80. The defendants entered into this agreement with full knowledge that the enterprise would rely on criminal means to achieve its objectives, including wire and mail fraud, obstruction of justice, whistleblower retaliation, and honest services fraud. These actions were not anomalies. They were foreseeable, orchestrated, and essential to the conspiracy itself. 81. Donlon was selected by Defendant Adams due to his stellar and accomplished reputation in law enforcement and intelligence communities in both the public and private sectors. Donlon became a primary target of the collective NYPD defendants because he refused to comply with their criminal conduct. His efforts to expose institutional fraud, abuses of authority, lack of experience over incompetence, and systemic corruption directly threatened the enterprise's continued operation. In response, the defendants, individually and collectively, stripped him of all responsibility, one excluded from ability to implement direct decision-making, and were insubordinate by ignoring his orders, and ultimately eliminated his position entirely. 82. These retaliatory acts were not incidental. They were coordinated and deliberate. fully consistent with the conspiracy's aim to protect itself at all costs. 83. As a direct and proximate result of the defendant's conspiracy, Donlon suffered significant injury to his business and property. These injuries include, but are not limited to, 1. The loss of salary and pension benefits, the destruction of future earning capacity, and irreparable harm to his professional reputation. 84. These damages fall squarely within the scope of civil RICO liability and entitled Donlon to treble damages, costs, and attorney's fees pursuant to 18 U.S.C. SS 1964. 85. The full extent of damages incurred by Donlon are to be determined at trial. D. Civil RICO Predicate Acts Chart. 2. Factual allegations predating plaintiff Thomas G. Donlon's employment as police commissioner, a systemic criminal enterprise within City Hall and the NYPD. 86. A municipality may be held liable under 42 U.S.C. SS 1983, where constitutional violations stem not from isolated misconduct, but from official policies, widespread customs, or deeply rooted practices. This doctrine, established by Monell v. Department of Social Services, 436 U.S. 658, imposes liability when systemic abuses are perpetrated or tolerated by policymakers with final authority. The facts set forth below establish such liability against the City of New York. 87. While the challenges within the NYPD long predate Defendant Adams, his administration allowed systemic dysfunction to metastasize into something far more dangerous: weaponized criminality. Rather than working to reform or stabilize the department, Defendant Adams empowered individuals with known histories of abuse and misconduct, while dismantling the careers and credibility of those who spoke out. Under his leadership, the machinery of public safety was not used to serve the people of New York City. It was repurposed to protect political allies and punish internal dissent. Whistleblowers were marginalized, retaliated against, and in many cases, forced out of the department altogether. 88. This failure of leadership does not reflect the values or commitment of the thousands of NYPD officers who serve with integrity. It is a reflection of the corrosive influence of City Hall under Defendant Adams, which allowed a proud institution to be bent for personal and political gain. 89. This was not a string of isolated incidents. What follows is a deliberate and sustained pattern of unlawful conduct, some of it plainly criminal, all of it unconstitutional or ethically indefensible. Together, these actions reflect a blueprint for institutional decay that was not only tolerated, but actively orchestrated by the failed leadership within the NYPD and the administration at City Hall. 90. The City of New York, under Defendant Adams, not merely failed to prevent misconduct, it encouraged, rewarded, and institutionalized it, regardless of the harm inflicted on individual officers, the public trust, or the city's integrity of Defendant City. 91st. Under Defendant Adams, high-ranking NYPD officials with well-documented histories of violence, dishonesty, sexual misconduct, and civil rights violations were not investigated or disciplined. They engaged in retaliation, cover-ups, and political intimidation, and were rewarded with power, protection, and promotion. These individuals never faced accountability for their actions, and no disciplinary actions were taken against them. If any of the rank-and-file officers acted in this manner, they would face disciplinary action, resulting in transfers, termination, and perhaps, in all likelihood, criminal charges. Those who upheld the law, including Donlon, were isolated, stripped of authority, and driven out. Defendant Adams's meddling often resulted in Donlon being improperly excluded from promotional, operational, administrative, and investigative decisions. 92. These are not managerial lapses. They are the predictable result of a municipal policy that prizes loyalty over legality and silences truth-tellers rather than confronting misconduct. The examples that follow, including public lawsuits, audit findings, and detailed patterns of abuse, demonstrate a widespread, deliberate practice of constitutional violations. The defendant city, under Defendant Adams, is not merely negligent, it is complicit. 93. Donlon accepted the role of interim police commissioner, with full knowledge of the sordid records of many top officials, which included defendants Kinsella, Madry, Shell, Daughtry, and Shepard. Donlon accepted the position not out of naivety, political alignment, nor personal gain, but out of loyalty to the rank-and-file officers, who, in spite of failed leadership, risked their lives each day to protect the public. The mission of Donlon was clear: restore administrative and operational integrity, improve interagency collaboration, and raise morale within a department bereft of competent, fair, and lawfully acting leadership. 94. Donlon, with his documented and significant experience working with U.S., federal, state, and local law enforcement and intelligence agencies nationwide, entered the administration of Defendant Adams, with a mandate to ensure the NYPD operated at its highest level. What he found instead was a deeply entrenched criminal enterprise, engineered by Defendant Adams and his political operatives, that used public office to extract loyalty, reward silence, and retaliate against internal dissent. Donlon, after having identified significant, egregious, unprofessional, in his view, criminal conduct by the named NYPD defendants, believed it was in the best interest of the NYPD and the public to remove these individuals from their positions, specifically defendants Kinsella, Madry, Shell, Daughtry, and Shepard. Defendant Adams continued, even after Donlon advised Defendant Adams of the crimes he witnessed, to allow them each a direct line to his Adams office. Donlon repeatedly was given strict instructions by Defendant Adams. "I want you to work with them." By the time Donlon fully understood the scale of the corruption surrounding him, he had already been marked for removal. Donlon felt compelled to remain with the NYPD, even after the individual defendants' true unlawful motives and the criminal enterprise were exposed, in order to try to protect the rank-and-file NYPD officers who fell under the NYPD defendants' unlawful reign. B. A culture of impunity. The NYPD fails to punish the many disciplinary issues of the individual defendants. 95. For years prior to and continuing through Defendant Adams's administration, the NYPD maintained a systemic pattern of shielding officers with serious disciplinary histories, promoting and rewarding them despite repeated warnings, internal complaints, lawsuits, and costly settlements. These decisions were not made in ignorance, they were made with full knowledge of the underlying misconduct. This entrenched pattern created a policy and practice of protecting abusers, undermining accountability, and enabling the very constitutional violations at issue in this case. 96. Rather than reversing course, Defendant Adams perpetuated and expanded this practice, choosing to elevate known abusers into positions of greater power and influence. This deliberate failure to discipline or remove problematic officers, despite overwhelming notice, directly links the city's policy-making officials to the misconduct alleged herein. 97. The long history of misconduct by the individual defendants herein is presented in chronological order. 98. On July 28, 2007, while on duty, Defendant Daughtry pointed his firearm at a civilian on a motorcycle and threatened, "Turn off the bike or I will fucking kill you." He was later issued charges and specifications for this incident. 99. In 2008, Defendant Daughtry pled guilty to the above misconduct and was docked 10 vacation days. Despite conduct that constituted the crime of menacing under New York state law, no criminal referral was made, and he avoided an NYPD trial. 100%. Also in 2008, Defendant Daughtry was issued a Schedule B command discipline for computer misuse, a disciplinary action reserved for more serious internal violations. 101. That same year, a U.S. Federal District Court judge in Manhattan, Judge John E. Sprizzo, found Defendant Daughtry not credible when testifying under oath in a gun arrest case. The Brooklyn District Attorney's Office publicly confirmed it would begin reviewing his other arrests for improprieties. At the time of this instant filing, the Brooklyn District Attorney's Office has yet not produced any documents or reports regarding this inquiry. 102. In 2008, Defendant Chell, at the time holding the rank of lieutenant, fatally shot a fleeing suspect, Hortense Beauval, in the back. No disciplinary action was taken. No firearms retraining was ordered. He remained in good standing with the department and no charges were filed. 103. In January 2012, Defendant Daughtry received another Schedule B command discipline after failing to notify a patrol supervisor of an incident involving an off-duty NYPD employee. He was docked 8 vacation days. Upon information and belief, as a result of the discipline, Defendant Daughtry was not transferred, removed from street enforcement, had his weapons confiscated, nor was he given remedial training over the incident. 104. In March 2012, Defendant Daughtry received yet another Schedule B command discipline. The nature of the infraction and number of days docked remains unknown. 105. In 2012, a federal jury awarded $2,500,000 to the family of Hortense Beauval for the fatal shooting by Defendant Chell. That verdict was later reduced through settlement to $1,500,000. 106. Upon information and belief, despite a jury verdict, that Defendant Chell was responsible for the death of Beauval, Defendant Chell received no remedial firearms training, was not transferred, or stripped of his service weapon. 107. It is incredulous and defies logic that Defendant Chell was allowed to remain a law enforcement officer after a civil jury found him responsible for the shooting death of a civilian. 108. Also in 2012, Defendant Chell was investigated, initially by the Internal Revenue Service, who then passed their information to the NYPD's IAB for falsely utilizing the tax identification numbers and identities of some of his family members when he, Defendant Chell, performed and was paid for employment outside the NYPD, specifically working as a basketball referee. By utilizing the tax identification data of others, this caused the actual true individuals to realize an increase in their taxable income, for which they were responsible for paying the appropriate taxes. 109. Ultimately, the IRS did not bring federal criminal charges, but Defendant Chell was issued internal disciplinary charges for the tax fraud. On May 29, 2013, Defendant Chell pled guilty to willfully attempting to evade or defeat a federal tax in the NYPD trial room, and that he received income for the period of time he worked off-duty employment under the name of a family member for tax deferral purposes. 110. It is extremely unlikely that Defendant Chell had permission to work the off-duty employment under a different name. NYPD policy is clear that all off-duty employment must be authorized beforehand and logically, utilizing one's true identity. 111. Similarly to when Defendant Chell was allowed to remain in his NYPD position after he was found to have unconstitutionally killed a civilian, the city continued to protect high-ranking officials despite serious misconduct. It is incredulous and deeply troubling that any law enforcement officer would retain their job after admitting to federal tax fraud. Yet under Defendant Adams's administration, such conduct is not only tolerated but shielded. These actions reflect a broader policy of rewarding loyalty over legality and protecting political allies regardless of their violations of public trust. 112. After he pled guilty to lying and committing tax fraud, Defendant Chell was only docked 10 vacation days by the NYPD and was allowed to continue in his career upward trajectory without any obstacles related to his unlawful actions. It is not erroneously speculative to believe that if any other MOS possessing a lower rank was involved in any of the above incidents, that MOS would certainly have been more severely disciplined or terminated. This illustrates why a great majority of NYPD MOS are disgusted and suffer from low morale, as there are a different set of rules of discipline and termination outcomes based on rank, title, and personal connections. Madry's admitted dishonesty in the NYPD's. 113. In 2016, Defendant Madry began a sexual relationship with Detective Tabitha Foster, a subordinate. The relationship led to a physical altercation between them, wherein Defendant Madry punched Detective Foster and then failed to report the violent altercation. 114. On May 5, 2016, Defendant Madry gave inaccurate and misleading statements during an official interview with IAB when questioned about his relationship with Detective Foster. 115. On February 1, 2017, Defendant Madry again provided false and misleading statements during an NYPD IAB interview, including false denials of the altercation. 116. In 2017, Defendant Madry was issued formal disciplinary charges for engaging in a physical altercation with someone, known to the department, failing to notify a supervisor, impeding an NYPD investigation, and providing false statements. 117. Defendant Madry pled guilty to the internal NYPD charges. His punishment, the loss of 45 vacation days. He was not suspended, demoted, or referred for criminal prosecution. 118. If a rank-and-file police officer pled guilty to lying to IAB regarding the same offense, they would be more than certainly terminated for lack of candor. Defendant. Madry faced no real discipline for his admitted lies and was allowed to continue in his upward career trajectory without any obstacles related to his unlawful actions. 119. Similarly, in the FBI or any other federal law enforcement agency, if a special agent or civilian employee is proven to have lied, they are, in all likelihood, or immediately terminated for lack of candor and face possible federal criminal charges for violations of 18 U.S.C.S.S. 1001 ET-Sec. The obvious question is why this case involving Defendant Madry wasn't opened as a federal civil rights investigation. 120. Upon information and belief, despite pleading guilty to serious disciplinary charges, Defendant Madry received no remedial firearms training as a result of the discipline. 121. Defendant Madry, despite the admitted lack of candor on several occasions involving off-duty and on-duty actions, along with his horrific documented behavior, was surprisingly promoted to chief of the department. Donlon was certainly surprised and disappointed, having worked with so many numerous and highly talented NYPD executives who were not selected over Madry for this prestigious position. 122. The defendant city allowed a known sexual predator, Defendant Madry, to remain employed within the NYPD, enabling him to continue harming women under the color of authority. 123. On October 26, 2020, then Inspector Defendant Saraceno pled guilty to misusing department time, falsifying department records, and failing to timely submit required executive reports. He was allowed to retire instead of the NYPD pursuing a criminal case. His pension was preserved, and he forfeited only 30 vacation days in his remaining leave balances, as referenced above, after nearly 1 year of retirement. Defendant Madry reinstated Defendant Saraceno to the NYPD at the rank of Inspector. 124. On June 3, 2020, Defendant Shepard violently assaulted a female protester during a demonstration and ordered the false arrest of a civilian witness, Ernesto Lopez, who filmed the incident. The NYPD later settled with Mr. Lopez for $400,000. 125. On June 4, 2020, Defendant Shepard again engaged in violent misconduct. He tasered protester Destiny Strudwick without cause and ordered her false arrest. Mrs. Strudwick was hospitalized due to her injuries. The city later paid her $99,000 in settlement. 126. In May 2019, Defendant Daughtry was again disciplined through a Schedule B command discipline for failing to safeguard his NYPD-issued body-worn camera. 127. In May 2020, despite this growing record of violations, Defendant Daughtry was given a discretionary promotion to Detective Second Grade. D. Proven sexual misconduct results in rewards for NYPD bad actors. 128. In February 2021, Captain Sharon Bally sued the defendant's city and senior NYPD officials for sexual harassment and retaliation, which received widespread news coverage. Her allegations included multiple male supervisors making sexually explicit comments in front of her and attempting to access the bathroom while she was showering. One officer even bragged about masturbating at her desk. These acts were reported but ignored. 129. When Captain Bally filed a sexual harassment complaint with the NYPD's Office of Equal Employment Opportunity, it was sent to Captain James Coble, who immediately alerted the officers she had named, placing her at greater risk. Rather than protect Captain Bally, the NYPD retaliated against her until she was forced to resign. 130. Shortly after the complaint, which was leaked by Captain Coble, he was rewarded by the NYPD's Office of Equal Employment Opportunity, where he oversaw all of the discrimination and retaliation investigations in the NYPD. 131. In December 2021, the city settled Bally's lawsuit for $800,000. Despite the size and seriousness of the settlement, none of the accused officers were disciplined. To the contrary, they were each rewarded with promotions, commanding officer positions, and/or lucrative assignments within the NYPD. 132. In January 2022, Deputy Inspector Andrew Arias, one of Captain Bally's harassers, was promoted to commanding officer of the Hate Crimes Task Force. In January 2023, another accused officer, Captain Harriton Marachilian, was made commanding officer of the 90th Precinct, just 13 months after the defendant city paid out nearly $1 million for his prior conduct. 133. The promotions of these individuals is an embarrassment not only for the NYPD, but for law enforcement as a whole. The NYPD is known as the preeminent municipal law enforcement agency in the United States of America, and for it to reward these egregious individuals with promotions is embarrassing and just plain wrong. E. Defendant Adams consolidates power and elevates loyalists. A. City Hall's takeover of NYPD leadership. 134. On January 1, 2022, Defendant Adams was sworn in as mayor of the city of New York. 135. From the outset, Defendant Adams's administration stripped the NYPD of independent leadership and centralized power in a tight-knit circle of political loyalists, many of whom had already been implicated in prior misconduct. 136. That same day, Defendant Adams appointed Keechant Sewell the 45th Police Commissioner of the NYPD. Her tenure, however, was undermined from the beginning. Defendant Adams installed two of his longtime allies, Philip Banks and Timothy Pearson, as de facto overseers of the department, bypassing her authority. 137. Philip Banks was appointed Deputy Mayor for Public Safety, despite previously being named an unindicted co-conspirator in an FBI corruption investigation and having $300,000 in unaccounted for money in his bank account. Tim Pearson, known for a history of sexual misconduct, which included on-duty sexual incidents and accusations of sexual abuse and harassment, was simultaneously brought into City Hall as a senior advisor for public safety. Though neither held formal command positions within the NYPD, they began directing NYPD operations through shadow influence. 138. Under this structure, fomented and condoned by Defendant Adams, Banks and Pearson effectively led the NYPD. They regularly overruled Police Commissioner Sewell and assumed control of promotional decisions, assignments, and strategic operations. As a result, the NYPD ceased to function through the long-established chain of command. Power was wielded based not on rank, merit, or civil service law, but on personal allegiance to Defendant Adams. 139. The NYPD's discretionary promotions, which under the NYC Administrative Code SS 14-114 are supposed to be made solely by the police commissioner, were taken over by Banks and Pearson. Promotions below the rank of captain were controlled by Pearson. Promotions above the rank of captain were finalized by Banks. It was subsequently reported that the police commissioner had little to no meaningful input in the discretionary promotional process or who received the benefit. 140. These discretionary promotions came with substantial financial benefits, including salary increases, overtime eligibility, and pension enhancements, often totaling hundreds of thousands of dollars per officer. Banks and Pearson used this power to reward loyalty, punish dissent, and entrench their control over the department. 141. This arrangement constituted a direct violation of the law. It also created a promotional economy where corruption, not competence, dictated advancement. The consequence was devastating. Qualified officers were sidelined while unqualified loyalists with disciplinary records were vaulted into leadership. 142. In practice, final promotion lists were sent from the NYPD to City Hall, then reviewed and edited by Banks and Pearson. Promotions were often contingent on political connections, loyalty to Defendant Adams, or willingness to ignore misconduct. This backroom system gutted the NYPD's credibility and created a shadow structure of power wholly detached from public accountability. 143. Banks and Pearson made no secret of their authority. They regularly met with NYPD personnel across all ranks and inserted their allies into key command roles. Police Commissioner Sewell was repeatedly overruled or bypassed entirely. Even high-ranking chiefs deferred to the political operatives instead of their lawful superior. 144. These acts usurped the statutory powers of the police commissioner and transferred them to unelected, unaccountable individuals under Defendant Adams's personal direction. The NYPD was no longer a paramilitary institution governed by a chain of command. It had become a political patronage machine, serving the personal interests of City Hall rather than the public good. 145. This structural breakdown of lawful authority was not theoretical. It had tangible and dangerous effects. Discretionary promotions became rewards for silence or complicity. Loyalty to the mayor's circle was prioritized over integrity, experience, or constitutional compliance. Senior leadership positions were filled with individuals known for abuse, retaliation, and dishonesty. 146. The result was a law enforcement agency being led by officials who had no lawful claim to their roles and no accountability to the people they served. The NYPD's command structure was no longer based on merit or civil service. It was built on cronyism, coercion, and personal allegiance to a political regime. 147. The illegal consolidation of power under Defendant Adams, Banks, and Pearson created the precise environment that allowed the retaliation against Donlon to flourish. It also violated the statutes and civil service rules designed to prevent political interference in law enforcement. These were not minor infractions. They were structural and deliberate, and they set the stage for the constitutional violations that followed. 148. Banks and Pearson operated as political enforcers within the NYPD, routinely overriding or sidelining the police commissioner. Promotional decisions, command assignments, and disciplinary outcomes were no longer made by the commissioner as required under New York City Charter SS 435 and Administrative Code SS 14-114. Instead, these decisions flowed through the mayor's inner circle. 149. Under this unlawful scheme, promotions below the rank of captain, such as detective second and first grade, sergeant special assignment, and lieutenant special assignment, were reviewed and finalized by Pearson. Promotions at the rank of captain and above, including deputy inspector, inspector, deputy chief, and bureau chief, were controlled by Banks. 150. The promotional process was entirely corrupted. Recommendations were sent to City Hall, where Banks and Pearson modified the lists based on political loyalty, favoritism, and personal agendas. Commissioner Sewell was routinely forced to sign off on pre-selected candidates, stripping her of statutory discretion and rendering her office a facade. 151. As reported in several media outlets, numerous high-ranking officers personally witnessed Banks and Pearson dictating promotions and commanding officer assignments. Multiple sources had confirmed to reporters that senior staff within the office of the police commissioner were instructed to defer to Banks and Pearson rather than follow internal NYPD protocol. In several instances, the Commissioner Sewell was completely bypassed in operational decision-making. 152. Sewell herself raised concerns. According to internal communications and reporting, she protested this interference and attempted to reassert her authority. In response, Banks and Pearson further marginalized her and used back channels to direct senior NYPD staff without her input. 153. This deliberate consolidation of power violated New York City law, undermined public safety, and transformed the department's internal governance into a patronage system. Promotions were granted not on merit, but on loyalty to allies of Defendant Adams. 154. Many of these discretionary promotions conferred financial benefits, such as increased pay, access to overtime, and pension enhancements. By controlling the process, Banks and Pearson gained personal influence and political capital through a system that directly impacted salaries, career advancement, and post-retirement benefits. 155. This conduct likely constitutes honest services fraud under 18 U.S.C. SS 1346. Banks and Pearson used their positions to orchestrate a pay-to-play promotion scheme, depriving the public of the NYPD officials' honest services by corruptly influencing official acts for personal and political advantage. 156. These were not abstract abuses. Qualified officers were bypassed, retaliated against, or pushed out, while unqualified loyalists, including individuals with documented disciplinary histories, were rewarded. The command structure of the NYPD was no longer grounded in law, merit, or public interest. It had become a shadow government operating at the discretion of Defendant Adams. 157. These actions had cascading effects throughout the department. Morale collapsed, transparency disappeared, and the rule of law was subordinated to political expediency. The systematic sidelining of the police commissioner made clear that integrity and independent oversight would not be tolerated. The same actions were also reinformed under Donlon's administration as interim police commissioner. 158. The city of New York cannot escape liability for these actions. It knowingly permitted unelected, unvetted political actors to commandeer the largest municipal police force in the United States, an enterprise that now functioned in direct violation of the city charter, civil service rules, and federal law. C. Defendant Adams continues to reward bad actors in the NYPD. 159. On January 4, 2022, Edward Caban was appointed First Deputy Commissioner of the NYPD, the second highest-ranking position in the department, subordinate only to the police commissioner. This promotion came despite Caban's extensive disciplinary history, including formal punishment for using his NYPD-issued vehicle for personal errands on at least 96 occasions. 160. At the time of his appointment, Defendant Adams and senior NYPD leadership were aware of Caban's past misconduct. Nevertheless, he was elevated to the most powerful position in New York City law enforcement. 161. Just 1 month later, in February 2022, Defendant Adams, either directly or through his proxies, placed Captain Andrew Arias in command of the NYPD's Hate Crimes Task Force. Arias had been a central figure in the sexual harassment and retaliation claims raised by Captain Sharon Bali, whose lawsuit against the NYPD and multiple officers resulted in an $800,000 settlement by the city less than 3 months earlier. 162. Despite his documented involvement in a hostile and retaliatory work environment, Arias faced no disciplinary consequences. Instead, he was rewarded with a high-profile assignment typically made at the discretion of the police commissioner. Under normal circumstances, Commissioner Sewell would have been credited with that decision, if, of course, Arias merited it. But under Defendant Adams, such appointments were routinely directed by Banks and Pearson. 163. Arias's promotion exemplifies the administration's pattern of protecting and elevating officials implicated in civil rights and sexual misconduct cases, provided they remain politically loyal. 164. On May 8, 2022, the New York Post reports troubling new allegations which emerged against Caban. Through Freedom of Information law requests, the Post learned that Caban had been accused of cheating on his sergeant's examination and was disciplined in 4 other misconduct cases. Caban was accused of engaging in multiple inappropriate sexual relationships with female subordinates. Reports allege that Caban had several sexual encounters with NYPD employees, and that he provided preferential treatment to officers with whom he had sexual relationships. 165. These actions constituted serious violations of NYPD policy, civil service rules, and federal workplace protections. Yet neither the NYPD nor defendant city took action. Instead, the allegations were actively suppressed, protecting Caban and insulating the department from public accountability. 166. The failure to investigate or discipline Caban, despite credible claims that he engaged in sexual acts with subordinates, while on duty and in a position of supervisory authority, demonstrates a deliberate pattern of concealment and complicity. Caban has never faced formal charges or disciplinary review for these acts. 167. What makes this all the more egregious is that this conduct was known to defendants Adams and City at the time of Caban's promotion to First Deputy Commissioner. His advancement, despite serious, disqualifying misconduct, exemplifies the administration's policy and practice of rewarding those accused of sexual misconduct and rights violations as long as they remained within the mayor's political circle. 168. On July 22, 2022, the City of New York agreed to pay $99,000 to settle a federal civil rights lawsuit filed by New York City residents Destiny Strudwick and Yasmin Gertz against the defendants City, Shepard, and several other NYPD officers. The suit stemmed from a 2020 protest in which defendant Shepard tasered and falsely arrested MS Strudwick, causing injuries that required hospitalization. 169. Despite the severity of the allegations and the city's monetary settlement, defendant Shepard was not disciplined. Instead, he was later promoted to Deputy Commissioner of Public Information on November 17, 2022. Another example of advancement in the face of known misconduct orchestrated by Pearson and the collective defendants. 170. In January 2023, Harriton Marichillian, another officer named in Captain Balley's sexual harassment lawsuit, was promoted to commanding officer of the 90th Precinct. This promotion occurred just 13 months after the city settled the case for $800,000. Rather than face any consequence, Marichillian was elevated, further demonstrating the city's policy of protecting and rewarding those accused of physical and sexual harassment. 171. Marichillian's promotion was approved under the watch of Defendant Madry, then Chief of Department, and Defendant Adams. Both were aware of the lawsuit and its resolution. The elevation of Marichillian, despite such serious allegations, reinforced the message that sexual misconduct would not only be tolerated, but rewarded if politically convenient. 172. The NYPD's failure to investigate, discipline, or even acknowledge the misconduct described above is not a series of isolated lapses. It is a sustained and deliberate policy. These acts reflect not negligence, but a conscious municipal choice to reward loyalty over legality and suppress dissent over transparency. The Critical Response Team, a rogue unit created to project power, not ensure safety. Formation of CRT outside of lawful oversight channels. 173. In the fall of 2022, the NYPD, under the direction of Defendant Daughtry, through a series of stylized videos posted on the NYPD's website, which is operated by the defendant city. 174th. These videos showcased aggressive street enforcement tactics, unconstitutional stops, and unlawful vehicle pursuits, many of which likely violated the 4th and 14th Amendments. The CRT videos made it clear the unit operated without legal constraint and with full backing from the mayor's office. 175. On paper, CRT was described as an elite crime-fighting unit launched under Defendant Adams. In practice, it was a rogue enforcement team that operated outside the NYPD's traditional chain of command, answerable only to City Hall. During his tenure, Donlon was never informed of CRT's existence or history, nor was the unit mentioned in weekly executive meetings involving the NYPD's top-ranking 3-star and 2-star chiefs. Typically, the police commissioner would be debriefed on the actions of an enforcement unit like CRT and its accomplishments. But Donlon was kept in the dark. 176. This secrecy was deliberate. CRT's activities were intentionally concealed from Donlon by defendants Madry, Chell, and Daughtry, despite their presence at the same executive meetings. The exclusion of the police commissioner from oversight of a citywide enforcement unit reflects a profound breakdown in command accountability. 177. Defendant Daughtry, who had no prior administrative or operational experience as a commanding officer, was placed in charge of flawed CRT. Daughtry treated the unit as a personal fiefdom, allowing officers to pursue both real and imagined suspects at high speed through city streets, frequently in violation of NYPD policy. These pursuits often resulted in serious injury and, in some cases, death. 178. Defendant Chell, a key leader within CRT, stated publicly, "Our mayor had given us the mandate to start playing offense out here." That statement was not a metaphor. CRT was used to harass, injure, and violate the rights of civilians, particularly in communities of color, with no regard for constitutional safeguards. 179. On or about October 5, 2022, Defendant Daughtry pled guilty to making misleading official statements to the Civilian Complaint Review Board on February 21, 2021 and July 29, 2021. For the admitted lack of candor, Defendant Daughtry was only docked 20 days, 180. If a rank-and-file police officer pled guilty to lying to IAB, they would be terminated or suspended for lack of candor. Defendant Daughtry faced no real discipline for his admitted lies and was allowed to continue in his employment with Defendant City without any obstacles related to his unlawful actions. 181. On December 2, 2022, despite CRT's growing record of abuse, Defendant Chell was promoted to Chief of Patrol by Defendant Adams. 3 weeks later, on December 23, 2022, Defendant Daughtry was promoted to Detective First Grade, a rare and highly coveted honor, despite his history of unconstitutional policing. B. Patterns of unconstitutional policing and excessive force. 182. In early 2023, a scathing internal audit by retired NYPD Chief Matthew Pontillo found that CRT officers were systematically conducting unlawful stops, failing to file stop reports, and ignoring internal documentation policies. The audit concluded that the CRT was operating in open defiance of both NYPD rules and constitutional law. 183. Rather than curtail CRT's activities, Defendant Adams took to Instagram in a public relations stunt, posing in CRT's khaki uniform and writing, "Turning out with the team." His post came just weeks after the audit's release and was widely interpreted, correctly, as a direct rebuke to efforts to hold CRT accountable. 184. In effect, CRT reported directly to Defendant Adams in City Hall. When higher-ranking officers attempted to intervene or raise objections, they were overruled. Defendants Chell and Daughtry maintained a direct line to Defendant Adams, who personally intervened to preserve CRT's autonomy and shield its actions from scrutiny. The CRT lacks any meaningful policies, guidelines, or procedures. There is no indication that the NYPD Legal Bureau approved or even saw the techniques being used by Defendants Chell and Daughtry with CRT. 185. Due to the absence of oversight, the CRT appeared to operate with impunity, haphazardly assaulting the public without any goals, objectives, or accountability mechanisms. 186. According to investigative reporting by ProPublica, Defendant Adams had direct access to CRT officers' body-worn camera footage, an extraordinary and irregular level of control that bypassed standard NYPD oversight mechanisms. See Public Endorsement of Lawlessness by Defendant Adams. 187. In one particularly egregious instance, a senior NYPD attorney raised legal objections to CRT's unconstitutional conduct. Rather than heed the legal advice, Defendant Adams demanded to know whether the objections were based upon law or opinion, and angrily insisted that the actions proceed, permitting Defendant Daughtry to ignore the attorney's guidance and continue with the unlawful policing operation. 188. CRT's methods implemented by Adams mirrored more outrageous behavior as the disbanded anti-crime unit, which Defendant Adams has previously stated his intention to change. The concept and responsibilities of anti-crime unit was to avoid discriminatory tactics in anti-crime efforts, aiming for a more targeted and less harmful approach. Adams was concerned about discriminatory policing within the NYPD, leading to continued oversight. 189. However, once in power, Defendants Adams, Madry, Chell, and Daughtry allowed CRT to operate without any formal operational plan, which included policies, procedures, and guidelines. 190. Operational plans, accountability structure, or legal review, targeting minority communities in precisely the same issues that led to the dismantling of the original anti-crime unit concept by Adams. 191. Upon assuming the office as the mayor of New York City, Defendant Adams sought to bring back the anti-crime units that had been previously eliminated due to the abuse that these units caused. Their engagement in racially motivated policing and were known to have trampled on the constitutional rights of New York City residents. While in office, Defendant Adams brought back the anti-crime unit as an anti-gun unit that targeted illegal firearms and gang activity, utilizing officers selected and trained to prevent discriminatory practices. This effort was not sustained. 192. Under Defendant Daughtry, as cited above, the anti-gun unit morphed into the CRT. Essentially, Defendants Adams and Daughtry resurrected the former anti-crime handbook with new guidelines and procedures, rebranding it CRT. Defendant Adams, who had publicly identified the constitutional issues surrounding the former anti-crime unit during his campaign for mayor, welcomed and continues to welcome the unlawful techniques and practices of the CRT. 193. The brutality of CRT operations was not accidental. It was the predictable outcome of a lawless mandate given by Defendant Adams himself. CRT became the enforcement arm of Defendant Adams's political strategy, a tool for projecting tough-on-crime optics at the expense of civil rights and constitutional law. 194. As the city's highest-ranking policymaker, Defendant Adams's endorsement of CRT, despite ongoing civil rights audits, demonstrates more than indifference. It reflects a calculated effort to normalize unconstitutional policing. 195. These actions support mono liability by establishing an official policy or custom that violated New Yorkers' constitutional rights. Despite media reports exposing CRT's abuses, no new guidelines or reforms were implemented. G. Retaliation, suppression, and First Amendment violations. A. Retaliation against whistleblowers within the NYPD. 196. On April 11, 2023, a civilian NYPD employee filed a civil lawsuit alleging that Lieutenant Whittler Lucas, then serving as Integrity Control Officer for the NYPD's Property Clerk Unit, had sexually assaulted her in his office while on duty. The allegation was particularly alarming given Lucas's role as an internal accountability officer responsible for departmental integrity. 197. Despite the seriousness of the allegation, which described an on-duty sexual assault by an officer tasked with internal oversight, Defendant City failed to take even basic precautionary measures. Lieutenant Lucas was not placed on desk duty, nor was his firearm removed, both of which are standard protocol when serious misconduct allegations are substantiated. 198. The inaction was so pronounced that the victim was forced to seek a family court order of protection just to compel the NYPD to disarm Lucas. This unprecedented step underscores the department's complete abdication of responsibility in handling serious workplace sexual violence. 199. Just months later, in June 2023, the limits of the police commissioner's authority was exposed when then-Commissioner Sewell sought to discipline then-Chief of Department, Defendant Madry, for a separate serious act of misconduct. 200. In that incident, Defendant Madry appeared in person at the 73rd Precinct in Brownsville, Brooklyn, and ordered officers to null and void a gun-related arrest involving a former NYPD officer with whom Defendant Madry had a personal connection. The order was a blatant abuse of authority and a direct violation of NYPD policy. 201. The Civilian Complaint Review Board investigated the incident and substantiated the misconduct. Commissioner Sewell determined that discipline was warranted and intended to act accordingly. B. Weaponization of internal affairs and legal processes. 202. In spite of the determination made by then-Commissioner Sewell, Defendant Adams and his senior aides intervened to block any meaningful discipline. They lobbied Police Commissioner Sewell directly to ignore the CCRB's findings and protect Defendant Madry from accountability. This is further evidence of the mayor's control over disciplinary outcomes in cases involving political loyalists. 203. Ultimately, under pressure from City Hall, Commissioner Sewell issued a token penalty, docking Defendant Madry 10 days' pay. Upon information and belief, the decision reflected not her independent judgment, but the mayor's refusal to permit discipline of his inner circle, even in the face of clear policy violations. 204. This episode highlighted what was already becoming apparent across the NYPD. The police commissioner no longer held true disciplinary authority. Defendant Adams, acting as both political overseer and de facto final arbiter of NYPD discipline, had stripped the office of the police commissioner of meaningful power when it came to holding high-ranking officers accountable. In particular, those officers whom Defendant Adams viewed as loyalists and his protectors. 205. The NYPD's failure to disarm an accused sexual predator, combined with the egregious interference by Defendant Adams in a case involving a clear case of abuse of power by the Chief of Department, reflects a pattern of deliberate inaction and political protectionism that violates constitutional norms and emboldens further misconduct. 206. In or about May 2023, Deputy Inspector Andrew Arias was promoted to Deputy Chief in the NYPD despite his active participation in the incidents that gave rise to the Captain Sharon Bally sexual harassment lawsuit, which the defendant city paid $800,000 to resolve. H-City liability under Monell and federal civil rights law. A. The policy and practice of protecting abusers and punishing reformers. 207. On June 16, 2023, NYPD Police Commissioner Keechan Sewell resigned from her post after enduring months of systemic obstruction, unlawful and political interference by Defendant Adams and his senior aides. 208. Like Plaintiff Donlon, Commissioner Sewell had been stripped of the core authority required to lead the department. Key decisions. including disciplinary measures, promotions, transfers, and public messaging, were micromanaged or outright dictated by City Hall. Commissioner Sewell was regularly bypassed by Defendant Adams and his inner circle at City Hall and at the NYPD, rendering her title functionally meaningless. 209. Upon information and belief, the only logical conclusion surrounding the departure of Commissioner Sewell and subsequent media reports was not that she voluntarily resigned, but that she was forced out. As a result, her resignation was a constructive discharge, driven by Defendant Adams's sustained campaign to strip Commissioner Sewell of her institutional power and undermine her efforts to hold senior NYPD officials accountable. Any reasonable person in her position would have felt forced to resign under such conditions. 210. Commissioner Sewell's resignation came just days after Defendant Adams's intervention to block her efforts to discipline Chief of Department Defendant Madry for misconduct, a clear demonstration that her authority as commissioner had been hollowed out to protect politically connected insiders. 211. On July 17, 2023, Defendant Adams appointed Edward Caban as her replacement, despite Caban's extensive and well-documented history of sexual misconduct. 212. These allegations were widely reported in the New York Post and other media and known to NYPD leadership and City Hall at the time of Caban's appointment. Yet no investigation was initiated, and Caban faced no meaningful consequences. Instead, he was rewarded with the highest position in the NYPD. 213. The refusal by Defendant Adams and Defendant City to discipline Commissioner Caban, or even acknowledge the seriousness of the allegations, demonstrates a deliberate policy of protecting senior officials who engage in sexual misconduct, provided they remain politically loyal to the administration of Defendant Adams. 214. On the same day Caban was appointed commissioner, the New York Post published a revealing exposé stating that Defendant Daughtry, then a detective first grade, was widely viewed as the real boss of the NYPD. The article reported that senior NYPD brass routinely bypassed the commissioner and went directly to Defendant Daughtry to request transfers, promotions, and other key decisions. 215. Despite having no official authority over such matters, Defendant Daughtry had effectively supplanted the commissioner's role, functioning as Defendant Adams's political enforcer within the NYPD and directly undermining the chain of command. 216. Rather than correct this unlawful power structure, Defendant Adams formally rewarded it. On July 17, 2023, the same day Caban was elevated to commissioner, Defendant Daughtry was promoted to assistant commissioner, despite his troubling disciplinary history and complete lack of qualifications for the role. 217. The assignment of Defendant Daughtry to the position of assistant commissioner, despite having no supervisory experience, is as incredulous as it is irresponsible. In this major role of responsibility within the NYPD, the position typically requires an extensive supervisory skill set, which is needed to make operational and administrative decisions. To have placed someone like Defendant Daughtry in this position is not only detrimental to the NYPD, but also places a MOS in difficult and potentially life-threatening positions, and the public in harm's way. 218. These appointments were not based on merit, experience, or in the best interests of the NYPD. They were political rewards for loyalty and silence, part of a broader pattern by the City of New York to shield wrongdoers and dismantle lawful oversight structures within the department. Tim Pearson exerts unlawful influence over NYPD operation and promotions. 219. On July 22, 2023, Tim Pearson, despite holding no official NYPD role, conducted an interview for the senior leadership position of Deputy Commissioner of Public Information. Pearson's involvement was a clear overreach of authority. 220. The DCPI role falls under the police commissioner, not an unelected advisor like Pearson. This exemplifies the inappropriate political interference at the NYPD's highest levels. 221. Pearson's involvement was not an anomaly. It was part of a broader pattern in which high-level NYPD promotions were controlled, not by the police commissioner, but by City Hall operatives loyal to Defendant Adams. Pearson's de facto authority over hiring decisions reflected the erosion of lawful procedures and institutional independence within the NYPD. 222. On August 1, 2023, just days after Pearson conducted the interview, Lieutenant Widler Lucas was formally indicted by the King as county district attorney for 2 counts of a criminal sexual act, as well as charges of sexual misconduct and aggravated harassment. These charges stemmed from an on-duty sexual assault of a subordinate NYPD employee, allegations the department had been aware of for months. 223. At that time, Defendant City had a clear and lawful pathway to discipline. Lucas, he could have been suspended with pay pending the outcome of the criminal trial then, terminated through internal disciplinary proceedings. This process, if followed, would have triggered pension forfeiture upon conviction. 224. Instead, the defendant's city, with the approval of then Police Commissioner Edward Cabin, permitted Lucas to quietly retire with full vesting of his 17-year pension, despite the severity of the charges and the potential 20-year prison sentence he still faced. 225. Upon information and belief, allowing an officer who has been indicted on sex charges to retire with his pension is unprecedented. No formal explanation was provided for this departure from standard procedure. The lack of disciplinary follow-through, particularly for a senior officer facing violent sex crime charges, was so unusual and improper that it demands comprehensive investigation. 226. Just 6 days after Lucas's indictment, on August 7, 2023, then Commissioner Caban formally promoted defendant Shepard to the position of DCPI, placing him in charge of managing the NYPD's public messaging and media relations. 227. Defendant Shepard's appointment, facilitated by Pearson and rubber-stamped by Commissioner Caban, highlighted the NYPD's politicized promotions. Positions were awarded not based on merit, but on political loyalty. 228. Upon assuming the DCPI role, the division nearly doubled in size, growing from 46 to 86 officers, despite patrol shortages. This unchecked expansion illustrates gross mismanagement and a lack of oversight, implicating both Adams and Caban. CRT's unconstitutional reign of violence and abuse spreads across New York City. 229. On August 16, 2023, in response to a growing number of reckless and dangerous police chases, Defendant Madry issued an internal memorandum to at least 6 top NYPD officials, including defendants Chell and Daughtry, reminding them that all officers must adhere to the NYPD's written policy on vehicular pursuits. 230. The memorandum emphasized that a vehicle pursuit must be terminated whenever the risks to members of the service and the public outweigh the danger to the community. If the suspect is not immediately apprehended, this was not a discretionary guideline. It stemmed from the NYPD's legal and constitutional duty to safeguard both civilians and officers from unnecessary harm. 231. The directive followed 2 particularly disturbing incidents. On August 12, 2023, 5 Staten Island-based police officers were injured during a high-speed pursuit of a suspected minivan thief. Just days later, a second pursuit ended in disaster when the fleeing suspect crashed into an SUV, flipping the vehicle and injuring 2 children, ages 1 and 5, who were passengers. 232. On August 15, 2023, a 54-year-old woman riding a bicycle was hit and critically injured by a suspect fleeing from detectives investigating illegal firearms. The woman was left fighting for her life due to the CRT's reckless chase tactics. 233. These back-to-back incidents reflected a broader pattern of CRT-led operations that violated not only NYPD policy, but also basic standards of public safety and constitutional policing. No operational plans governed CRT's actions. Unchecked abuses continued without any discipline or consequence. 234. Rather than issue a corrective statement, Defendant Chell publicly bragged about the tactics. In a subsequent interview, he said, "We're pretty good at it, and we're going to continue stopping cars and bikes that are breaking the law." His statement reflected not just defiance, but a complete disregard for the violence and legal violations carried out under his watch. 235. Multiple other incidents further illustrated the CRT's dangerous and lawless behavior. 236. In one instance captured on a body-worn camera, an NYPD officer, while pursuing an unlicensed motorcyclist, swerved into the fleeing motorcyclist and caused the motorcyclist's death. 237. In another, a NYPD commander was caught on cell phone video punching and kicking an unlicensed motorcyclist in the head. 238. In yet another, NYPD officers stopped a civilian without any apparent legal basis. 239. In one particularly egregious case, a CRT officer repeatedly grabbed a male civilian's genitals during a stop, without conducting a search elsewhere on the body. That same civilian was later issued a summons for littering. 240. When the man attempted to complain about the sexual assault and unlawful stop, a CRT officer slammed him into a nearby window. 241. These are not isolated incidents. They are the foreseeable result of a policing culture encouraged and protected by Defendant Adams. At every turn, Defendant Adams condoned the CRT's excessive and unconstitutional tactics, refusing to impose oversight or discipline. 242. On May 31, 2024, the City of New York agreed to pay $400,000 to settle a federal lawsuit brought by Ernesto Lopez, who alleged that defendant Shepard violated his constitutional rights. Despite this substantial payout and the seriousness of the allegations, defendant Shepard faced no disciplinary action or punishment whatsoever. Another example of being protected by Marian Adams. Certainly a lower-ranked MOS would not have been as fortunate. 243. The absence of accountability, lack of control and defined goals, in the face of clear, repeated constitutional violations, some of which resulted in serious injury and death, demonstrates defendant. Cities, under the administration of defendant Adams, established custom, policy, and practice of condoning unlawful police conduct when carried out by loyalists within the defendant Adams administration. First, mismanagement, retaliation, and corruption continue unchecked. Defendant Adams takes no action. 244. In September 2023, NYPD officer Hugh Tran was involved in a violent road rage shooting in southern New Jersey after a day of heavy drinking. During a seemingly random traffic encounter, Tran inexplicably opened fire on a young businessman, leaving the man permanently paralyzed. The shooting was senseless, unprovoked, and entirely preventable. 245. At the time of the shooting, Officer Tran was under the direct command of Defendant Shepard. 246. Defendant Shepard had long been aware of Officer Tran's serious struggles with alcoholism and prior alcohol-related misconduct. Rather than initiate intervention, mandate treatment, or remove Tran from active duty, Defendant Shepard deliberately concealed the issue, allowing a clearly impaired officer to remain armed and on the streets. 247. This supervisory negligence created a foreseeable and extreme risk to public safety. Defendant Shepard's deliberate indifference to a known threat directly enabled the events that led to the shooting. Now, as a result of his failure, defendant city faces potential legal liability that could cost taxpayers millions of dollars. 248. Despite this grave failure of leadership and oversight, defendant Shepard had faced no discipline or professional consequence for his role in this tragedy. The defendant city's refusal to act underscores the entrenched policy of shielding misconduct when perpetrated by individuals loyal to defendant Adams. 249. On or about September 7, 2023, a female NYPD sergeant filed a lawsuit under New York's Adult Survivors Act, alleging that NYPD Detective First Grade Neftali Cruz raped, stalked, and terrorized her during and after their romantic relationship. 250. Despite the seriousness of these allegations, which include violent sexual assault, stalking, and intimidation, the defendant city of New York and the NYPD permitted Cruz to quietly retire in early, November 2023, retaining his full pension, department-issued firearm, and a good guy letter, which is often used to secure future employment in law enforcement or security. 251. Under NYPD policy, the IAB and the Department Advocate's Office are granted 30 days from the date an officer submits retirement papers to initiate disciplinary proceedings. Despite the gravity of the rape allegations, NYPD attorney prosecutors informed the sergeant's counsel that 30 days was not enough time to investigate the matter and bring internal charges. 252. This was not an isolated incident. Just a few months earlier, the same NYPD attorney prosecutors permitted Lieutenant Jonathan Lucas to retire with full pension benefits, even after he was formally indicted for serious sex crimes and making violent threats while stationed at the NYPD property clerk warehouse. Once again, no internal charges were brought, and Lucas was allowed to exit the department without consequence. 253. In November 2023, the corruption surrounding defendant Adams reached a new level of visibility. A summons with notice was filed in New York County Supreme Court under the Adult Survivors Act, accusing defendant Adams himself of sexual misconduct. 254. On November 6, 2023, FBI special agents executed a federal search warrant at City Hall and seized defendant Adams's electronic devices as part of a wide-ranging corruption investigation. 255. When defendant Adams was asked by the FBI special agents for the passwords to his electronic devices, defendant Adams falsely claimed he had forgotten the password to one of his phones, an implausible excuse meant to obstruct the investigation. Data recovered from the device revealed that defendant Adams had lied about the phone's location and availability. 256. Upon information and belief in the aftermath of the search, certain NYPD officials provided defendant Adams with an untraceable burner phone, enabling continued communication with the NYPD defendants and other members of his political inner circle. 257. Upon information and belief, the provision of this burner phone by NYPD officials was done to shield defendant Adams's ongoing misconduct and allow the continuation of what now appears to be a coordinated criminal enterprise involving senior leadership in the employ of defendant city and NYPD. 258. Also, on November 6, 2023, FBI agents executed a search warrant on the home of Brianna Suggs, a longtime aide to defendant Adams, as part of the same corruption investigation. This further confirmed the breadth and seriousness of the misconduct surrounding the defendant Adams administration. J. Plaintiff's counsel warns defendants of First Amendment retaliation. City responds with further indifference. 259. On November 25, 2023, the New York Post published a story on the lawsuit of Officer Ahmed Elmanshoy, who had been removed from the NYPD's Personnel Bureau after allegedly speaking too much Arabic. The removal raised serious concerns of discrimination and retaliation. Deputy Commissioner, defendant Kinsella, inviting him in to discuss his lawsuit. 261. However, when Elmanshoy arrived, he was not met by NYPD leadership for a constructive dialogue. Instead, he was confronted by defendant Shepard, who berated him for exercising his First Amendment rights by speaking publicly about his legal claims. 262. The beratement of NYPD officers by defendant Shepard is typical of the way he interacted with subordinates in the NYPD. 263. This bait-and-switch tactic, luring a whistleblower under false pretenses, ostensibly for a meeting to have a gentleman's discussion regarding the lawsuit and then retaliate against him amongst the trappings and power of the office of defendant Shepard, constitutes direct and unlawful First Amendment retaliation. 264. Elmanshoy amended his lawsuit shortly thereafter to add defendant Shepard as a named defendant, citing this blatant retaliatory act. 265. The incidents described above reflect an unbroken chain of constitutional violations, retaliatory abuse, and deliberate inaction by defendant city and its highest officials. Defendant Adams, despite mounting scandals and criminal inquiries, had taken no action to curb the corruption or misconduct within his administration. Instead, he had enabled and protected it at every turn. 266. On December 1, 2023, counsel for Officer Ahmed Elmanshoy, Attorney John Scola, emailed defendants Kinsella, Madry, Gerber, and David Goldfarb, Miguel Iglesias, and Wendy Garcia, formally placing them on notice of unlawful First Amendment retaliation within the NYPD. 267. The email informed city and NYPD leadership that defendant Shepard had been added as a named defendant in Elmanshoy's pending civil rights lawsuit for engaging in direct retaliatory conduct, including berating the officer for public speech about his legal claims. 268. The email served as a cease and desist notice, demanding that defendant city and its officials immediately cease all forms of retaliation against Officer Elmanshoy and any other employees engaged in protected speech, including media communications as private citizens regarding lawsuits. 269. Despite this clear warning, the defendant city took no corrective action. Defendant Shepard was neither investigated nor disciplined. No accountability followed. This failure to act sent an unmistakable message. Retaliation for protected First Amendment activity would be tolerated, if not implicitly endorsed, at the highest levels of the NYPD and City Hall. 270. Defendant City further entrenched this retaliatory culture by indemnifying defendant Shepard for his unlawful conduct, protecting him from personal liability despite clear evidence of unconstitutional retaliation. 271. That same month, in December 2023, the defendant City quietly settled the civil lawsuit stemming from Lieutenant Widler Lucas's on-duty sexual assault for $1,200,000. 272. Defendant City declined to provide Lucas with legal representation during the civil proceedings, acknowledging that his conduct, sexual assault of a subordinate while on duty, was criminal and outside the scope of employment. 273. Nevertheless, defendant City exercised its discretionary authority to allow Lucas to leave the NYPD without facing internal discipline and to retire with his full pension intact, effectively shielding him from employment consequences, while his criminal prosecution remained pending in Kings County Criminal Court. This course of action is highly unusual and is rarely, if ever, done in this manner. As a result of the NYPD's misguided kindness, Lieutenant Lucas, who had been arrested for sexually assaulting an NYPD civilian while on duty, was allowed to retire with his pension benefits. 274. These incidents, taken together, show how the defendant Adams administration weaponized policy discretion to reward loyalty, protect abusers, and silence whistleblowers, while ignoring constitutional obligations and public trust. K captain promoted following sexual harassment and city payout, then arrested for violent felony. 275. On December 7, 2023, NYPD Captain Harriton Marachilian, previously promoted under the authority of Defendant Adams despite well-known allegations of misconduct, was arrested in Passaic County, New Jersey. He was charged with first-degree kidnapping, assault, criminal restraint, and criminal coercion. 276. The charges arise from a shocking and violent incident in which Captain Marachilian allegedly kidnapped a fellow NYPD female captain, slammed her head into the dashboard of his car, and, when she attempted to flee, chased her down, caught her, and body slammed her onto the concrete. 277. The brutality of the assault underscores the dangerous consequences of defendant city's repeated decisions to promote known sexual abusers into positions of authority and public trust. 278. His prosecution is ongoing as of the filing of this complaint, and Captain Marachilian remains incarcerated in New Jersey. 279. Marachilian's elevation to commanding officer of the 90th Precinct came despite multiple red flags. Defendant City, through the actions of its top officials, was fully aware of prior allegations against him, including sexual harassment and inappropriate conduct that previously led to a substantial civil rights settlement. Conversely, the female captain, who he harassed, was forced to resign from the NYPD and relocated to a different state to escape the abuse. 280. Nevertheless, rather than investigate or discipline Marachilian, defendants Adams, Madry, and others rewarded him with a high profile, command, prioritizing personal loyalty and internal politics over public safety, professional ethics, and the well-being of NYPD personnel. Defendant Adams rewards and further emboldens the defendants. 281. The pattern of rewarding misconduct continued on February 6, 2024, when Defendant Daughtry was promoted to Deputy Commissioner of Operations. This promotion came despite Defendant Daughtry's well-documented record of civil rights violations, excessive force, and policy infractions. His elevation sends an unmistakable message. Constitutional abuses are not only tolerated, but they are also rewarded. 282. Defendant Daughtry continued to be promoted despite his lack of credentials, experience, or operational experience. The repeated promotion of officers like Defendant Daughtry, who lack qualifications for their promotions, is irresponsible and an affront to all the hard-working employees of the NYPD and the public. 283. Just 3 weeks later, on February 29, 2024, Defendant Shepard used his public NYPD social media platform on X to launch a politically motivated and baseless attack on the judiciary. In a now notorious tweet, Defendant Shepard falsely accused New York State Supreme Court Judge J. Michelle Sweeting of improperly releasing a civilian charged with possession of stolen property and narcotics. 284. Defendant Shepard not only mischaracterized the charges and the circumstances of the release, but he also identified the wrong judge. His inflammatory post publicly misled the public, threatened judicial independence, placed the judge's life and safety in jeopardy, and reflected grossly unprofessional conduct by a high-ranking NYPD official. 285. In response to the false public accusations, Al Baker, spokesperson for the New York State Office of Court Administration, issued a formal rebuke. The recent social media posts from NYPD officials criticizing a recent bail decision not only indicated that the crime allegedly took place in the wrong county, but it also named a judge that did not preside over the case. 286. Despite the gravity of this misconduct, which included misinformation, public intimidation of the judiciary, and abuse of official power, Defendant Shepard faced no disciplinary action of any kind. This stands in stark contrast to the treatment of lower-ranking NYPD employees, who would almost certainly face consequences for far less egregious behavior. 287. Upon information and belief to date, Defendant Shepard has not apologized for his mistakes related to this social media post. 288. In March 2024, another longtime close advisor to Defendant Adams, Winnie Greco, had her home searched by FBI agents. The search was reportedly related to corruption investigations implicating City Hall, and a further indication of the lawless climate that had flourished under Defendant Adams's leadership. The sexual misconduct within the administration becomes fully known. Again, no disciplinary action is taken. 289. On March 21, 2024, Defendant Adams was formally accused of sexual assault by a former CO worker stemming from his time as an NYPD officer. 290. Rather than recuse himself from involvement or follow proper protocols, Defendant Adams demanded representation by the New York City Law Department, a request that, under standard guidelines, should have been denied as the conduct allegedly fell well outside the scope of official duties. Nevertheless, the law department was coerced into compliance. 291. That same month, on March 21, 2024, retired NYPD Sergeant Roxanne Ludeman filed a civil lawsuit alleging rampant sexual harassment and retaliation. Her complaint named Senior Mayoral Aide Timothy Pearson, Defendant City, Defendant Madry, and IAB Group 1 Commanding Officer Joseph Profeta as defendants. 292. Despite the gravity of the allegations, Defendant Adams refused to initiate disciplinary action against Pearson or any of the individuals named in the lawsuit, furthering a well-established culture of silence and protection for high-level abusers. 293. Ludeman alleged that between December 2022 and April 2023, she was repeatedly sexually harassed by Pearson, who leveraged his power over discretionary promotions, including a pending Sergeant Special Assignment designation, as a coercive tool to solicit sexual favors. 294. NYPD Chief Miltiadis Marmara personally witnessed Pearson touching Ludeman inappropriately. So serious was the conduct that Marmara was forced to restructure office operations to ensure Pearson was never alone with a woman on staff. 295. Despite Ludeman's proven qualifications and placement on the promotional list, Pearson removed her name and instead advanced a less qualified male colleague, Patrick Gordon, who had personal ties to Pearson. 296. This promotion manipulation exemplifies the NYPD's long-standing pattern of elevating loyalty over merit, integrity, or professional qualifications. 297. Pearson's actions appear to constitute not only civil violations, but also potential honest services fraud and other criminal acts, the full extent of which is still unfolding. 298. After Chief Marmara confronted Pearson about the harassment, Marmara was stripped of his elite outside agency position and sent back to NYPD, a clear act of retaliation. 299. Pearson then coordinated with Defendant Madry and Profeta to retaliate against Ludeman, Sergeant Michael Ferrari, Lieutenant George Huang, and Chief Marmara for challenging his conduct. 300. Pearson ordered NYPD Chief of Internal Affairs Miguel Iglesias to open retaliatory investigations into all three male supervisors and Ludeman. These investigations had no legitimate basis and were instead designed to punish those who had exposed Pearson's sexual misconduct. 301. Pearson even went so far as to secretly record a meeting with Marmara, seeking evidence to support the fabricated investigations and shield himself from accountability. 302. Over the course of 2023, these retaliatory campaigns intensified, forcing Ludeman and Ferrari into early retirement. 303. This abuse of authority, where the NYPD was weaponized to silence whistleblowers and protect a close political ally, violated the constitutional rights of both defendant city employees and civilians alike. 304. Defendant Adams was fully aware of the retaliatory campaign but took no action to stop it, continuing a pattern of complicity and protectionism that defined and still defines his administration. 305. As a result, Sergeant Ferrari and Lieutenant Huang filed their own lawsuits against Defendant City, Defendant Madry, and Pearson, alleging unlawful sexual harassment and retaliation. 306. Even after these additional legal actions, Defendant Adams continued to shield the perpetrators from discipline. 307. Defendant Madry faced no consequences for his repeated involvement in retaliatory misconduct, including in the Ludeman case and others. 308. The continued employment benefits and protections afforded to Defendant Madry and Pearson, despite multiple lawsuits and well-substantiated misconduct, further establish that Defendant City, Defendant Adams, and the NYPD defendants knowingly condoned these constitutional violations and failed to take corrective action. 309. Defendant Adams's repeated refusal to hold his inner circle accountable had emboldened illegal conduct at the highest levels of city government and law enforcement, further entrenching the defendant city's use of the NYPD as a tool for personal and political retaliation, and the defendant's attempt to distract the public from Defendant Adams's escalating legal troubles. 310. In March 2024, as public scrutiny over Defendant Adams's alleged sexual misconduct intensified, Defendant Chell engaged in a series of confrontational exchanges with journalists on Twitter, now known as 10th. 311. Rather than uphold standards of professionalism, Defendant Chell was allowed, if not encouraged, to use his public platform to attack reporters who covered the NYPD and its leadership critically. 312. These online attacks, which targeted the free press, were not only tolerated, but publicly condoned by Defendant Adams. 313. Among those targeted were New York Daily News reporter Graham Raymond and journalist Harry Siegel, a columnist, senior editor, and podcast co-host of FAQ NYC. 314. Defendant Shell even created his own Instagram account, which, coupled with the Twitter accounts of several high-ranking NYPD officials, including the individual defendants herein, blurred the line between private and NYPD business. 315. Defendant Shell's combative posture appeared calculated to redirect public attention from the growing scandals facing Defendant Adams and senior aides like Tim Pearson, both of whom were facing serious allegations of sexual misconduct. 316. In April 2024, defendants City, Adams, Madry, Shell, and Daughtry were named as defendants in a federal lawsuit filed in the Eastern District of New York. The complaint alleged that these officials weaponized confidential information about plaintiff's 2017 rape to retaliate against her for publicly criticizing violent policing tactics, particularly those employed by a controversial deputy inspector of the 73rd Precinct in the Brownsville section of Brooklyn, NY. 317. The plaintiff had originally sought assistance from defendant Madry and had been encouraged to file a police report. 318. Thereafter, the plaintiff alleged that NYPD officials cut off her nonprofit organization's access to precincts in Brooklyn and instructed local commanders not to engage with her. 319. Ultimately, sensitive and confidential details about her sexual assault were leaked and circulated among community advocates, deliberately mixed with misinformation suggesting that she fabricated the attack and had falsely accused a black man of rape. 320. This retaliatory conduct highlights a deeply rooted pattern within the NYPD and City Hall: the use of state power to suppress, intimidate, and discredit both internal whistleblowers and external critics. 321. The weaponization of trauma, specifically the leaking of sexual assault details to silence dissent, is not an isolated incident. It reflects a broader custom and practice of retaliating against protected speech and civil rights activity. 322. Despite the severity of the allegations, no action was taken to discipline defendants Madry, Shell, or Daughtry, confirming that such conduct remains officially condoned by the city. 323. On March 30th, 2024, President Donald Trump spoke outside the funeral home where the wake of NYPD Detective Jonathan Diller, who was killed in the line of duty, was being held. 324. From various sources, it was widely known that Defendant Shepard ordered NYPD officers to stay far away from President Trump so they would not be seen in the background of photographs and media videos of President Trump speaking. 325. Specifically, Defendant Shepard ordered the present NYPD MOS outside the funeral home. He does not want any NYPD uniformed personnel surrounding or in the background of President Trump's press conference. Upon information from reliable sources, Defendant Shepard stated to wit, "We don't want to show any NYPD solidarity with Trump." Many of the NYPD officers who received Defendant Shepard's order followed it, while others felt the order violated their civil rights. 326. On April 10, 2024, in an extraordinary and deeply unethical move, without prior notice to nor approval by the NYC Corporation Council, Defendant Adams bypassed the New York City Law Department and hired a private attorney using public funds to represent him in the aforementioned sexual harassment lawsuit. 327. This self-serving use of taxpayer money underscores Defendant Adams's willingness and total disregard to exploit public resources in order to protect himself and his inner circle from accountability for illegal acts. 328. Despite the clear breach of the Defendant City Protocol, Defendant Adams is allowed to act unchallenged and violate well-established procedures without any repercussions. 329. Defendant Adams has no checks and balances over his unlawful actions and uses the NYC taxpayer funds to shield the criminal enterprise he controls from being exposed. 330. Defendant Adams's actions reveal a persistent pattern, disregard for legal norms, abuse of power, and public manipulation, all in service of shielding a corrupt and retaliatory enterprise from scrutiny. 331. On May 3, 2024, several New York City Council members urged Defendant Adams to discipline the NYPD defendants herein for their repeated violations of ethical laws, but he again refused to act. 332. On May 10, 2024, following months of disrespectful social media posts attacking journalists covering the NYPD, the New York City Council held a formal hearing over the issue. 333. At issue were the NYPD defendants' repeated tweets labeling protesters as garbage and attacking a New York City elected official, whom they stated should be voted out of office. 334. These social media posts amounted to personal attacks on private citizens and elected officials, conduct that was plainly unethical and entirely unbecoming of NYPD leadership. 335. New York City Council Speaker Adrian Adams stated at the hearing The conduct of Defendant Chell and others was dangerous, unethical, and unprofessional, noting that included in the department's mission is to preserve the peace, protect the people, and reduce fear. 336. Further, New York City ethics laws, as well as internal NYPD standards, guidelines, and protocols, bar police officials from using New York City resources, such as NYPD social media accounts, for blatantly political purposes. 337. Despite being subpoenaed, defendants Chell, Daughtry, and Shepard defiantly did not attend the morning budget hearing with permission from Defendant Adams, thereby avoiding public accountability for their misconduct. Donlon was not surprised at Adams' abhorrent and disrespectful behavior towards the Speaker and the entire NYC Council, as Adams, along with Chell, Doughty, and Shepard, routinely show no respect to others but all demand respect. 338. Defendant Adams permitted the individual defendants to routinely violate defendant city rules, regulations, policies, and disregard oversight efforts by the New York City Council, which is statutorily charged with monitoring the increasingly unrestrained operations of the NYPD. 339. Defendant Adams failed to discipline the defendants herein for their repeated ethical and legal violations, thereby condoning their misconduct and emboldening further abuses. 340. The many failures of Defendant Adams, which often rewarded select individuals for disrespectful behavior and contempt, sends the wrong message to the rank-and-file officers of the NYPD. Donlon advised this behavior, and demeanor is well known by MOS of all ranks. 341. The distorted message was that one does not have to take responsibility for their actions. They do not have to adhere to or show respect to the NYPD's rules and policies, and moreover, writ large, the procedures, policies, and guidelines long established and enshrined by New York City. This undermined further the NYPD, which is tasked with working and communicating with the New York City Council to ensure communities within New York City are safe and protected. Defendant Adams forces the law department to break policy to indemnify co-conspirator Tim Pearson, forcing the resignation of the city's highest-ranking attorney. 342. On May 31, 2024, the New York City Corporation Counsel, the Honorable Sylvia Hines Radix, resigned from her position as head of the law department due to mounting internal conflict over the defendant city's decision to represent and indemnify Pearson in multiple sexual harassment lawsuits. 343. It was later revealed through the reporting of Politico that Defendant Adams personally intervened to force the law department to indemnify Pearson, despite credible, corroborated allegations of sexual misconduct, including eyewitness testimony from senior NYPD officials. 344. This decision was in direct violation of long-standing New York City policy, which governs when indemnification and legal representation are appropriate. The misconduct alleged against Pearson, including sexual harassment for personal gain, was plainly outside the scope of his official duties and therefore disqualifying under established law department guidelines. 345. The controversy was further compounded by reports that the rift began when Defendant Adams similarly forced the law department to represent him in a separate sexual assault lawsuit, again, despite the allegations falling well outside the scope of his public employment. 346. Defendant Adams had repeatedly compelled Defendant City to finance the legal defenses of himself and his inner circle, even when their conduct clearly violated the law and ethical norms. 347. These decisions reflect a broader abuse of public funds and power. By using taxpayer money to shield himself and his allies from accountability, Defendant Adams has undermined the independence of the law department and corrupted the purpose of public indemnification. 348. During this time, the law department was also actively investigating the sexual harassment claims brought by Sergeant Roxanne Ludeman. That investigation revealed that the defendant city had direct knowledge of Pearson's misconduct since at least December 2022 and had failed to stop it, nor put an end to these clear and concise claims. 349. Despite defendant city's internal awareness and corroborating testimony, including from Chief Miltiades Marmara, who reported and witnessed Pearson's inappropriate conduct, Pearson was never disciplined. Instead, he was allowed to remain in his powerful post as senior advisor to the mayor. 350. Following these events, Politico reported that Corporation Counsel Hines Radix's resignation was directly caused by the defendant city's insistence on defending Pearson, despite corroborated allegations of sexual misconduct. 351. The testimony confirming Pearson's misconduct included multiple recorded interviews with high-ranking officials like Chief Marmara, whose statements left no doubt as to the veracity and seriousness of the harassment. 352. In forcing the law department to break its own ethical standards to protect himself and his close ally, Defendant Adams fundamentally compromised the integrity of the city's legal apparatus and deepened the public harm already caused by Pearson's actions. Q. As repeated lawsuits continue to be filed, NYPD defendants are rewarded by Defendant Adams. 353. For defendant city employees who are willing to go along with the unlawful conduct of the defendants herein, the rewards are obvious. 354. Joseph Profeta, a defendant in the Ludeman lawsuit and a key factor in shielding Lieutenant Lucas from discipline following credible allegations of sexual assault, was granted a discretionary promotion to inspector on May 31st, 2024. 355. This promotion was delivered personally by Defendant Adams on the NYPD's promotional stage, a ceremonial privilege rarely granted and clearly symbolic of political favoritism. 356. On July 16, 2024, Captain Gabrielle Walls commenced a lawsuit against the defendant's city, Assistant Chief and Commanding Officer of Patrol Bureau Brooklyn North Scott Henderson, and Defendant Madry. Captain Walls had been sexually harassed by Defendant Madry for several years, and by Chief Henderson following her promotion to captain and assignment into a Brooklyn North command. 357. Captain Walls' complaint describes years of sexual harassment by Defendant Madry, including repeated unwanted advances and attempts to kiss her. These repeated attempts occurred at various holiday parties and regularly when Captain Walls worked as a lieutenant in the 88th Precinct. The repeated harassment commenced when, now Captain Walls was promoted to lieutenant in 2015 and continued until she filed her lawsuit. 358. Captain Walls was forced to hide in her office in the 88th Precinct with the lights off to avoid Defendant Madry, reflecting the severity of the harassment and the unsafe working environment created by NYPD leadership. After getting promoted to captain, Chief Henderson, emboldened by his mentor and sexual predator Defendant Madry, also tried to kiss Captain Walls at work in the normal course of their employment. Captain Walls was horrified by the unwanted sexual harassment yet powerless to stop it, as Defendant Madry was running the NYPD. 359. The defendant city had actual notice of these events by July 16, 2024, if not earlier, yet failed to take any action to protect Captain Walls or discipline the perpetrators. 360. Assistant Chief Scott Henderson is a childhood friend and protege of Defendant Madry. After Captain Walls objected to the sexual harassment, she was denied a commanding officer position and discretionary promotion to deputy inspector. When she confronts Chief Henderson about the clear mistreatment, Henderson told her other women were promoted because they are willing to do things you aren't. 361. Despite these allegations, Henderson remained the chief of Brooklyn North, the highest command in that patrol borough, and just 2 ranks below NYPD chief of department, until he was forced to resign for lying in internal interviews with IAB related to the accommodation. He gave a woman officer to work from home for 15 months in June 2025. 362. Under the defendant's collective leadership, unlawful conduct, criminal acts, and workplace retaliation are not punished. They are rewarded. 363. On July 30, 2024, Chief Miltiades Marmara filed a lawsuit against the defendant city, Pearson, Defendant Madry, and Defendant Chell. 364. In that suit, Marmara attested that he personally witnessed Pearson inappropriately touching Sergeant Ludeman, who was Marmara's chief of staff. 365. After confronting Pearson, Marmara was stripped of his prestigious assignment and targeted for retaliation, a clear example and part of the broader culture of silencing dissent within the NYPD. 366. Despite this corroborating testimony by Marmara, the defendant city failed to discipline Pearson in any meaningful way. 367. Following the lawsuit, Defendant Chell, well known throughout the NYPD and the outside communities for his heavy usage of alcohol, telephonically contacted Chief Marmara while intoxicated and berated him for filing the lawsuit. 368. Defendant Chell's retaliatory behavior didn't end there. At a meeting of the NYPD's most senior officers, including bureau chiefs and assistant chiefs, Chell publicly disclosed the existence of Marmara's complaint and declared that he looked forward to being deposed. 369. During the same meeting, Chell emphasized he worked under Defendant Madry, insinuating allegiance and retaliatory intent, effectively placing a target on Marmara's back in front of the NYPD's highest-ranking officials. 370. No disciplinary action was taken against Defendant Chell for this obvious act of intimidation and retaliation, reflecting a pattern of misconduct and deliberate indifference that runs from precinct-level retaliation to the highest ranks of City Hall. 371. The examples detailed above demonstrate a pervasive and deeply entrenched municipal custom and policy, tolerating and, in fact, rewarding misconduct that foreseeably resulted in the retaliation, silencing, and constitutional violations suffered by Donlon. 372. Each of the foregoing paragraphs is incorporated by reference and submitted in support of plaintiff's Monell claim under 42 U.S.C. SS 1983. 3. Factual allegations following plaintiff Thomas G. Donlon employment as interim police commissioner. A. The scope of the criminal investigations and potential criminal activity surrounding defendant Adams's appointees becomes known. 373. On or about September 4, 2024, the FBI searched the homes of multiple senior members of defendant Adams's administration and NYPD leadership, including Police Commissioner Edward Cabin, Timothy Pearson, Philip Banks, David Banks, Terrence Banks, and First Deputy Mayor Sheena Wright. Federal agents seized electronic devices and cash as part of a sweeping investigation into alleged bribery, corruption, and misconduct related to city contracts and NYPD discretionary promotions. 374. Commissioner Caban's home was reportedly searched in connection with criminal allegations involving his twin brother, James Caban, who was alleged to be collecting protection money from nightclubs in exchange for police intervention. In addition, Caban is under investigation by the IRS, per news media, for illegal conduct tied to discretionary promotions within the NYPD. 375. Philip Banks, already notorious for being an unindicted co-conspirator in a prior FBI federal corruption case involving $300,000 in unexplained income, as reported in the media, also had his phones confiscated pursuant to a court order. Banks avoided prior criminal charges, likely due to cooperation with federal investigators. 376. Banks's brothers, David and Terrence Banks, were likewise subject to electronic seizures by federal authorities, suggesting a broader pattern of coordinated misconduct within the defendant city's highest ranks. 377. Sheena Wright, first deputy mayor to defendant Adams, similarly had her phone confiscated and is under federal investigation. This further underscores the pervasiveness of potential criminal activity among defendant Adams's inner circle. 378. Despite these serious and credible allegations, defendant Adams took no meaningful action to remove or discipline any of the individuals implicated in these federal investigations. This inaction reflects a deliberate effort to shield his allies from accountability and reinforces the appearance of a coordinated and corrupt enterprise within the defendant's city. 379. Following the execution of the search warrant on Commissioner Caban's residence, the highest-ranking official within the NYPD at the time, public speculation intensified over his imminent resignation. 380. Upon information and belief. Defendant Madry also had search warrants executed by the FBI, who seized his electronic devices, seized and searched his residence. 381. Upon information and belief. Defendant Madry did not disclose that he was under investigation in order to remain in charge of the criminal enterprise which he ran, the NYPD. 382. On September 10, 2024, amid these unfolding events, defendant Shepard responded to a request for comment from a New York Post reporter by calling the journalist a fucking scumbag, a vulgar and unprofessional remark that once again went unpunished by defendant Adams. 383. On September 12, 2024, Commissioner Caban was ultimately forced to resign from his position as police commissioner. 384. Before resigning, Commissioner Caban issued a disciplinary ruling that exemplified NYPD's protection of insiders. Captain Antonio Pagan was found guilty of a sustained campaign of sexual harassment. 385. Despite the trial commissioner's recommendation for termination, Caban reduced the penalty to 60 vacation days. Pagan was allowed to quietly retire with full pension and benefits. 386. This wasn't an exercise of discretion. It was a calculated act of protection. Caban's decision, rendered after a federal search warrant had been executed but before his abrupt resignation, reflects a deliberate effort to shield connected officers from meaningful accountability. It underscores the same institutional rot that targeted Donlon, a criminal enterprise where misconduct is tolerated, discipline is manipulated, and anyone who threatens to expose the truth, like Donlon, is removed and retaliated against. 387. Even after Caban's resignation, the remaining close associates of defendant Adams, all under federal investigation, were allowed to retain their employment with the defendant city without any discipline or public acknowledgement of wrongdoing. 388. Immediately after Caban's resignation, plaintiff Thomas G. Donlon was contacted by person mutually known to Donlon and defendant Adams, B, Defendant Adams uses Donlon's credibility to legitimize a corrupt administration, then targeted him when he refused to stay silent. 389. Donlon is informed by a third party that Eric told him to call Donlon and inform him that Defendant Adams is considering Donlon for the police commissioner position and requested that Donlon interview for the position, which in fact he did. 390. Given the turmoil surrounding the FBI search warrants executed within the NYPD in Defendant's city, indictments, arrests, and resignations of many NYPD and public safety officials, along with publicly improper treatment of public officials by NYPD top executives, Donlon was concerned. Donlon was also concerned about the situation concerning the last two short-term police commissioners who resigned. Following the interview, Donlon stated he would only come in as an interim police commissioner. 391. Donlon was very much concerned and was told by many individuals that the four top executives, defendants Madry, Chell, Doughty, and Shepard, were all extremely anxious they would be appointed as police commissioner and were disappointed when Donlon was named. Donlon was also concerned not being legacy NYPD. His appointment would also be met with animosity and resentfulness. 392. After accepting the interim police commissioner appointment, Donlon's initial primary objective was to develop a close working relationship with the mayor, chief of the department, and all the bureau executives. First, beginning with the regularly scheduled Monday morning weekly meetings discussing NYPD city-wide administration and operational matters. 393. Donlon felt it was critical for him to join the organization and closely work with the top executives, bringing added value with his domestic international law enforcement and intelligence experience. 394. However, Donlon was very confident and excited that working closely with the NYPD, while with the JTTF NYS Homeland Security Section Chief, would make for an easy transition. 395. Despite the interim title, Donlon's objective was to support the mayor and his administration and the hierarchy of the NYPD, and wholeheartedly supported the rank and file. Donlon's primary objective was to bolster the development of all ranks, establish a program to mentor and instill confidence in a structured environment where veteran officers and supervisors actively develop tomorrow's NYPD leaders. 396. Donlon's concern was also that the NYPD executives who were close to Defendant Adams avoided any accountability or repercussions from by City Hall, due to their respective long-standing relationships with Defendant Adams. 397. Specifically, Donlon was concerned about the top executives defendants Kinsella, Madry, Chell, Daughtry, and Shepard, and their troubling and adverse reputations. 398. The many unchecked missteps in treatment of NYPD personnel by all of the above defendants were of great concern to Donlon. 399. Although his title was temporary, his overarching objective was unwavering: to restore the NYPD's integrity, guarantee equal treatment for all officers, and reinforce support for the rank and file. At the same time, he recognized that, as an outsider without a legacy NYPD background, his appointment might be met with animosity and resentment. 400. Unfortunately, the Monday morning meetings were largely unproductive. 401. At each meeting, Donlon would ask Defendant Chell for an update on the status of operations within the NYPD. Defendant Chell would respond by stating nothing to report. 402. Donlon was taken back by the lack of effort by Defendant Chell, who seemed to do as little work as possible. 403. Following multiple meetings, Donlon pulled Defendant Chell aside to inform him that as the chief of patrol, he should have information to report at the meetings. 404. Defendant Chell continued in his lackadaisical approach. See, Donlon is named Interim Police Commissioner based on his concerns with the position. 405. Donlon was named the Interim NYPD Police Commissioner on September 12, 2024, which was made official on September 23, 2024. 406. Despite his reticence and title distinction, Donlon believed he was taking the full position of police commissioner and all the responsibilities that came with it, to include making final decisions with input from experienced and competent executives. 407. After being named Interim Police Commissioner, Donlon quickly learned he had the position in name only and had no authority, control, or sole decision-making. This realization came to Donlon gradually as 409. As a result of his lack of decision-making and authority, despite his title, every statement made by Donlon contained herein is made as a civilian and not within the scope of employment, past or present. 410. A public employee is speaking as a private citizen when their speech is outside the scope of their employment in order to expose the rotting corruption and ineptness within a public organization. 411. Defendant Adams never intended to allow Donlon to actually function as the police commissioner, interim or otherwise. 412. As a result of Defendant Adams' premeditated intentions, Donlon's job duties as interim police commissioner were virtually non-existent, with defendants Kinsella, Medri, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino truly managing or operating the police department and disregarding all edicts on tasks, orders issued by and/or assigned by Donlon. 413. Each time Donlon expressed dissatisfaction about the unlawful actions of defendants Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino to defendants Adams or Madry, being the chief of the department, he was speaking as a private citizen, as he was the police commissioner in name only, as described above, as repeated above. 414. Again, Donlon's position as police commissioner was purely a figurehead position. 415. At all times herein Donlon's speech is protected under the One Stone Amendment to the United States Constitution. 416. After being named the interim police commissioner, Donlon met defendants Kinsella, Madry, Chell, Daughtry, and Shepard on the first day. 417. It did not take long for Donlon to fully understand, and unfortunately, it was confirmed that the defendants were going to be extremely problematic and not offer any support or respect towards him. 418. The collective NYPD defendants were determined for Donlon to fail and deliberately implored measures to do so and reinforcement, always complaining to defendants Adams or his immediate staff. 419. Donlon learned immediately from trusted sources within and out of the NYPD that defendants Kinsella, Madry, Chell, Daughtry, and Shepard were each angry and highly distraught they were not named NYPD police commissioner. 420. Defendant Shepard, more than the other NYPD defendants, was particularly openly hostile and resentful towards Donlon not being selected by defendant Adams, and quite clearly made his feelings known to defendant Adams. 421. Instead, defendant Shepard embarked on a pattern of behavior to sabotage, publicly undermine, and embarrass Donlon. 422. Defendant Shepard's hostility towards Donlon stemmed from his failure to be named police commissioner. Defendant Shepard's activities were done in a desire to curry further favor with defendant Adams, in order to prove to defendant Adams that the selection of Donlon was an error. 423. After spending time each of them, Donlon found the defendants Kinsella, Madry, Chell, Daughtry, and Shepard were unmanageable, insubordinate, inexperienced, and ineffective in their past and current roles. 424. While Donlon could tolerate personal discourtesy, the actions of defendant Shepard's blatant disregard for the office of the police commissioner was unacceptable. Both defendants Adams and Madry were fully aware of defendant Shepard's behavior, yet did not address his actions or discipline him. After a while, it was pointless. Directly confronting defendant Shepard proved pointless. 425. Defendant Adams, who had the leadership authority, never arranged meetings to address differences in the NYPD, while disallowing Donlon to lead the NYPD. Instead, defendant Adams let the situation fester. It was both embarrassing and demoralizing for Donlon to endure defendant Shepard's public display of disrespect and misconduct. Under normal circumstances, Donlon would not have tolerated such behavior, and many retired NYPD MOS and federal, state, and city task force members can attest to that, but Donlon tolerated the lying, cheating, and sneaky behavior to be there for the rank and file. 426. Shortly after taking over as police commissioner, the legal advisor to defendant Adams, Lisa Zornberg, a distinguished former federal prosecutor, abruptly resigned from the administration of defendant Adams. 427. It is subsequently reported Zornberg decided to resign after defendant Adams refused her advice to terminate Tim Pearson, Philip Banks, and Wynne Greco. Mrs. Greco was an aide to defendant Adams and separately was under federal investigation at that time. 428. Upon assuming his duties, Donlon brought 3 NYPD officers of various ranks to join his staff. Shortly thereafter, literally within a month, defendant Adams informed Donlon to remove these 3 MOS individuals from the police commissioner's staff. 429. Weeks later, defendant Adams informed Donlon that defendant Shepard would serve as his temporary chief of staff, while maintaining his permanent DCPI role. 430. During this time, Donlon also worked closely with a respected and experienced NYPD chief, who aided his transition. The chief's knowledge of policy and deep relationships both inside and outside the NYPD were invaluable. 431. Donlon had no desire for defendant Shepard to be assigned as temporary chief of staff, but complied with the directive from defendant Adams. Given defendant Shepard's prior hostility toward Donlon and others, Working with him posed significant challenges. 432. Despite this, Donlon followed Defendant Adams's order. Adams claimed that Shepard had experience putting these types of operations together, referring to the police commissioner's office, but provided no examples to support the claim. 433. Defendant Adams again stated, "I want you to work with him," as he previously stated about working with defendants Kinsella, Madry, Schell, and Daughtry. As always, Donlon advised Defendant Adams he has no issues or reason not to cordially work with Defendant Shepard or any of the above defendants. 434. While Donlon tolerated personal discourtesy, Defendant Shepard's open disrespect for the office of police commissioner was unacceptable. Defendants Adams and Madry were fully aware of Defendant Shepard's behavior, yet failed to intervene. 435. Donlon made multiple attempts to confront Defendant Shepard directly, but these proved futile. Defendant Adams, despite his authority, never convened a joint meeting to resolve the conflict. When Donlon attempted communication, Defendant Shepard would either walk away or respond with a violent outburst. 436. It was both embarrassing and demoralizing to endure Defendant Shepard's conduct. Under normal circumstances, Donlon would not have tolerated such behavior, and in their positions, Defendants Adams and Madry certainly had the power and personal relationship with Defendant Shepard and the responsibility to end it, but refused to intercede as a leader and rectify this continuous matter. Donlon would have done so immediately. 437. Defendant Adams also informed Donlon he is not allowed to schedule any media interviews unless it is known and authorized by Defendant Shepard. Donlon's attempt to discuss and provide guidance on NYPD's social media guidelines and procedures. 438. Donlon did not seek to limit the collective NYPD defendants' ability to give media interviews on behalf of the NYPD, but he also wanted to end the reckless and highly disrespectful social media practices which were resulting and proving to be an embarrassment to the NYPD. 439. Donlon informed all the present, all assistant, deputy, and bureau NYPD chiefs, along with other high-level uniformed and civilian employees at Donlon's first weekly Monday meeting, their individual public statements on social media outlets were reflective of the NYPD official public statement as an institution. Accordingly, prior to sending out individual messages on social media, it is required to first obtain the approval of the legal bureau. Donlon instructed all attending this regularly. 440. Donlon emphasized the necessity of a unified voice for the department on social media to address the growing problems caused by unchecked and unprofessional posts. 441. After the meeting, Donlon spoke privately with defendants Madry, Schell, Daughtry, and Shepard concerning the sending of their comments, in particular those sent by defendants Schell and Daughtry. Donlon advised they were unprofessional, unauthorized, and controversial social media posts to the news media, politicians, and the public regarding NYPD investigations and positions on NYPD matters. Donlon explained and presented to them the official NYPD policies, procedures, and guidelines manual, which must be adhered to before any NYPD information is released. Donlon advised the above they need to simply forward their proposed information to the NYPD Legal Bureau for their review and final approval. Donlon reiterated there needs to be one voice per enforcing the NYPD policies, procedures, and guidelines that will prevent embarrassment to the NYPD from outside entities, public and private sector, media, political figures, etc. 442. Donlon reiterated and clarified to all the attendees at the Monday meeting, to include defendants Madry, Schell, Daughtry, and Shepard, that this directive does not prohibit you from speaking with the media, political figures, or representatives of the public and private sectors. Although Shepard attended the initial meeting, he offered no comments about the dissemination of information, which was quite surprising as he held the position of Deputy Commissioner of Public Information, interacting with the media, etc., on a daily basis. Incidentally, Defendant Shepard seldom attended our weekly Monday morning executive meetings, nor did he designate a delegate. In practice, Defendant Shepard acted entirely on his own terms. Defendant Shepard made it abundantly clear to Donlon, on numerous occasions, and the entire command, that he had neither respect for nor interest in Donlon's authority or for the police commissioner position and what it represents and the PC beforehand. Defendant Shepard rarely attended these weekly scheduled executive Monday morning meetings, nor did he send someone in his place that Donlon was made aware of when Defendant Shepard failed to attend. In essence, Defendant Shepard did as he pleased when he wanted and was incorrigible and unmanageable. 443. It was quite apparent to Donlon and all the MOS who witnessed his demeanor, especially the 3 and 2 state chiefs, along with the NYPD civilian personnel at the Monday meetings, Defendant Shepard had absolutely no respect or time for Donlon. Despite the overt hostility, Donlon always approached Defendant Shepard with the utmost respect, attempting to develop a cordial relationship. 444. Unfortunately, Defendants Adams and Madry were fully aware of Defendant Shepard's behavior and allowed it to come to one. Arguing or verbally fighting with him was pointless, and Defendant Adams knew exactly what was happening, continued to let it fest as he made virtually no attempt to stop Defendant Shepard's behavior. It was extremely embarrassing for Donlon to tolerate Defendant Shepard's behavior, and it was demoralizing to Donlon to have Defendant Shepard act in this manner. Under normal conditions and circumstances, Donlon would have never tolerated Shepard's behavior. As leaders, Defendants Adams and Madry had the authority to end his bankrupt behavior but condoned it instead. 445. In the social media meeting, Defendants Chell and Daughtry became rather defensive and asked Donlon to show them the documents and posts he was referring to. As Donlon clearly stated, "I have a couple of folders in my office. Would like to see them." Defendants Chell and Daughtry did not respond. 446. Donlon further instructed Defendant Daughtry that he should not disable the feature on his software, which does not allow recipients of communications to provide any positive or negative comments to the posts. The person responding in general may have very valuable information for the NYPD, and turning off comments prevents the sharing of information. 447. Donlon was very concerned with the improper interference by Defendant Adams on his staff, which undermined the policy enforcements of Donlon and enabled continued misconduct. 448. Leading by example, Donlon sought approval of social media posts from the Legal Bureau prior to them being disseminated to the public, and hopefully avoid misconduct by the individual NYPD defendants. 449. This misconduct was later substantiated by an official report issued by the New York City Department of Investigation cited below. 450. Donlon focused particular attention on Defendants Madry, Chell, and Daughtry, holding a private meeting with them to underscore the importance of compliance with the policy. 451. Donlon's intervention was prompted by rampant social media abuses, including verbal attacks by NYPD officials on members of the media, political figures, in particular, NYC Council, Speaker Adrian Adams, and private and public sector individuals. Prior to Donlon's appointment as the Interim Police Commissioner, these unprofessional posts had already led to a public announcement that the Department of Investigation was investigating Defendants Chell, Daughtry, and the NYPD for misuse of social media. 452. Defendants Madry, Chell, and Daughtry resisted Donlon's directives, claiming the policy improperly limited their ability to engage with the public and private sectors. 453. Donlon clarified the policy applied solely to official communications, and the NYPD Legal Bureau review was standard NYPD departmental procedure, not a new restriction placed by Donlon. 454. To illustrate his concerns, Donlon referenced documented examples of prior problematic posts for their review. 455. Donlon spoke directly with Defendant Chell about how the Department of Investigation was investigating him for his rude and unprofessional comments. Donlon immediately undermined by Defendant Adams. 456. Within an hour of the above meeting concerning social media, Defendants Madry, Chell, Daughtry, and Shepard went directly to Defendant Adams separately to undermine Donlon, alarmingly, on his initial day as Interim Police Commissioner. 457. This usurping of power was indicative of the relationship between Donlon and the individual defendants from this point forward. No matter what Donlon tried to do to rein in the abuse of power, the individual defendants were allowed to ignore Donlon's orders as they had a direct access to Defendant Adams. 458. Shortly thereafter, Defendant Adams called Donlon to City Hall for a meeting in his office. At the meeting, Defendant Adams ordered Donlon to back off these guys. "They are my best 3 guys who are keeping crime down." 459. Donlon was shocked since he knew countless other NYPD personnel who were more intelligent and knowledgeable about police tactics and administration. In Donlon's assessment, each of the individual defendants, Kinsella, Madry, Chell, Daughtry, and Shepard, lacked the skills and police experience to serve in their appointed positions. 460. Other knowledgeable, experienced, and successful NYPD executives known to Donlon, he was unable or not permitted or directly contacting, and, considering for any of these high-level chief positions, possessed tangible experience while managing large-scale law enforcement and intelligence operations. 461. Unfortunately, these individuals sought by Donlon were unable even to attain positions or promotions in lieu of the actions of Defendants Adams, Kinsella, Madry, Chell, Daughtry, and Shepard. The aforementioned NYPD defendants lacked, in Donlon's assessment, the intelligence, essential administrative and operational experience required for the positions they hold. 462. Specifically, Donlon immediately saw that the individual defendants mentioned by Defendant Adams as his best guys had little successful police experience and virtually no experience in police major operations or administration. Donlon had reviewed the background of the top-tier executives of the NYPD prior, and when he assumed the post of interim police commissioner, and was mortified by their lack of experience. 463. Defendant Shepard, for instance, according to the NYPD website, had only effectuated 15 misdemeanor arrests, 5 felony arrests, and issued 2 violations in his entire 20-year career, according to the NYPD portal. Defendant Adams, while attaining the rank of NYPD captain, also had very limited arrests and no task force experience or a history handling major investigations. 464. Defendant Daughtry had no leadership experience and even stated that he failed the NYPD's civil service sergeant's examination. 465. Specifically, at a dinner attended by Donlon and several other NYPD executives, Defendant Daughtry, in which Defendant Daughtry was receiving a leadership award from one of the NYPD's fraternal organizations, Defendant Daughtry, unprompted, announced that he was a leader, even though I failed the sergeant's examination, repeating twice, "I am a leader." 466. Defendant Chell, during a chase, shot a civilian in the back, fatally killing him. He was exonerated but was civilly found guilty. 467. When Donlon became interim police commissioner and spent time assessing and closely working defendants Madry, Chell, Daughtry, and Shepard, he wanted to replace them due to their lack of experience in handling and managing investigations, but is not allowed by Defendant Adams. 468. Defendants Kinsella, Madry, Chell, Daughtry, and Shepard were essentially allowed to do whatever they wanted due to their personal relationship with Defendant Adams. 469. By meeting with defendants Chell, Daughtry, and Shepard, Defendant Adams undermined Donlon within days of him assuming the position. 470. As a result of their ability to circumvent the chain of command without consequence, defendants Chell, Daughtry, and Shepard went directly to Defendants Adams to complain about Donlon's executive orders, etc. Essentially, Donlon had no power or authority to make decisions or promote MOS within the NYPD. 471. When Donlon attempted to make changes within the police department, he was completely unsupported from doing so by the defendants herein, and in particular Defendant Gerber of the NYPD Legal Bureau. 472. Donlon, as stated and implied throughout this complaint, is of the belief that all of his communications and meetings with Defendant Adams were essentially those of a civilian speaking to a politician, and not those of a duly appointed interim police commissioner speaking with the duly elected mayor. Donlon was the interim police commissioner in name only, and he lacked the authority, as authorized by law, to carry out his official duties. 473. Donlon was not given the authorization by Defendant Adams to make any major decisions or properly manage the police department. Additionally, Donlon did not have the authority to supervise or discipline defendants Kinsella, Madry, Chell, Daughtry, Shepard, Saraceno, and Marino when they refused to follow his orders or report back to Donlon with expected answers. This is a direct result of Defendant Adams not supporting the police commissioner, and there has never been any recent mayor who has not backed or supported the police commissioner. 474. It should be noted that Donlon had no real choice in accepting the role of legitimate police commissioner under Defendant Adams, a leader who appeared to lack even the most basic sense of ethics, integrity, or moral responsibility. The gross mismanagement of the nation's largest police department under Defendant Adams devastated morale and performance across the NYPD. Rank-and-file supervisors patrolling the streets, as well as those in transit and housing, were left without guidance or support. Even the department's highest-ranking uniformed leaders, assistant and bureau chiefs, were routinely undermined and abandoned by the Adams administration. 475. At every turn, Donlon attempted to raise concerns about police corruption directly with Defendant Adams. Although Donlon repeatedly requested formal meetings, Defendant Adams was consistently unavailable. In contrast, Defendant Madry met with and advised Defendant Adams on a daily basis. Defendant Madry, the known sexual predator, acted as a gatekeeper, telling Donlon he would relay his concerns to Defendant Adams and deliver any messages on his behalf. Despite Donlon's good faith efforts to improve NYPD operations and address systemic corruption, Defendant Adams, shockingly and without justification, retaliated against him for his objections to the corruption. Defendant Adams diminished Donlon's authority, spread internal and external rumors that he would be fired, and ultimately carried out an unlawful termination in direct response to Donlon's efforts to hold the department accountable. 476. The NYPD is a paramilitary organization that operates under a chain of command structure to ensure maximized efficiency. 477. As a result of Donlon's lack of authority and power, and the ability of the individual defendants to speak directly to the mayor, Defendant Adams, this chain of command structure, is intentionally dismantled by Defendant Adams to allow defendants Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino to unlawfully control the entire NYPD is egregiously dangerous and unprecedented. 478. Moreover, Donlon is told repeatedly the individual defendants Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino resent the FBI, Donlon's federal background, and they do not want to work with federal law enforcement authorities, as voiced by Chell and Daughtry. 479. Throughout his time working as the interim police commissioner, Donlon's orders are disobeyed or ignored by defendants Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino. As previously stated, the above defendants were essentially in control of the entire NYPD in conjunction with Adams from the time of Donlon's appointment as the interim police commissioner in September 2024 until Donlon was retaliatorily terminated as police commissioner in November 2024. 480. When Donlon first met defendant Kinsella, she was cordial and expressed a willingness to support him in addressing NYPD-wide administrative and operational matters. She claimed she would bring forward valuable ideas, initiatives, and projects to improve the department's overall efficiency and morale, particularly among patrol officers and frontline supervisors. Despite these assurances, Defendant Kinsella never once offered tangible assistance or presented any of the initiatives she had promised. This included key concerns repeatedly raised by all NYPD unions, such as tour scheduling and morale. 481. Donlon requested that each of the bureau chiefs submit funding requests with the New York City Police Foundation in order to offset shortfalls in funding. Donlon provided the funding applications to the chiefs. The only chief who submitted the form was the chief of ESU, who submitted a request for $550,000 in funding, while the remaining chiefs failed to submit applications. To date, it appears that none of the chiefs took advantage of the application process and thus did not receive funding. 482. This failure to utilize resources harms not only the NYPD as a whole, but directly harms the rank-and-file officers who lack critical support. 483. At every turn, Donlon was instructed to stand down, and it was clear to Donlon that defendants Kinsella, Chell, Daughtry, and Shepard wield more actual power than any police commissioner. In practice, they function as the de facto police commissioners of the NYPD, exercising operational control, authority, and influence well beyond what the law permits them to do. 484. As noted above and emphasized herein, Defendant Adams summoned Donlon to City Hall on Donlon's first day as the interim police commissioner to advise Donlon that defendants Madry, Chell, and Daughtry are his three best guys, and that Donlon is to leave them alone. 485. This above conversation was pursuant to Donlon advising the above defendants and the entire NYPD staff regarding the use of social media and the abuses thereof, which needed to be authorized by the Legal Bureau before sending to the public. 486. The message from Defendant Adams to Donlon is unmistakable. Donlon is shocked and confused by the statement made by Defendant Adams. 487. As stated above, Donlon had reviewed their backgrounds of the individual defendants prior to taking the commissioner position and did not see any evidence of major successful operational experiences or a track record of success for any of the people Defendant Adams championed. 488. As a result, defendants Adams, Kinsella, Madry, Chell, Daughtry, Shepard, Gerber, Saraceno, and Marino, and several other connected chiefs connected to the defendants are allowed to do whatever they want within the police department, and Donlon is powerless to stop it. 489. This is further evidenced by the actions of defendant Shepard F. Following a police officer being shot in the line of duty, Commissioner Donlon discovers widespread incompetency in the highest ranks of the NYPD. 490. Donlon's leadership in a crisis was immediately tested on September 14, 2024, when an NYPD patrol officer was shot in Brooklyn. 491. While the officer thankfully recovered, Donlon's arrival at Brookville Hospital exposed a disturbing level of dysfunction within NYPD leadership. 492. Despite observing numerous dedicated members of service at the hospital, including high-ranking chiefs, inspectors, captains, etc., and numerous police officers. A subsequent briefing with defendants Madry, Shell, and police surgeon Dr. Kleinman revealed critical deficiencies to Donlon. 493. Defendant Adams's repeated phone calls to both Donlon and defendant Madry for updates during this crisis underscored the urgent need for structured communication, a need that would be contemptuously ignored. 494. Recognizing the potential for chaos and misinformation, Donlon explicitly directed defendants Madry and Shell to establish a centralized email communication system and chain of command for consistent and accurate updates to defendant Adams and key stakeholders, NYPD supervisors at the scene. This effort was to ensure that the NYPD has one correct, united message at the scene of a serious incident or event. 495. This simple, crucial directive, designed to prevent the real danger of relaying unverified information to defendant Adams and ensure collaborative communication, was met with blatant inaction. Both defendants Madry and Shell stated, when defendant Adams calls them individually, they then update him. Amazingly, they both totally missed Donlon's message. As Donlon said, defendant Adams has been calling others at the scene, including Donlon, and all need to have the latest information to provide to defendant Adams. Donlon stated that he was certain that all other NYPD bosses at the scene, Borough Commander, ESU Chief, Precinct Commander, and our medical division, Dr. Kleinman, and certainly the doctor would provide an excellent update to defendant Adams. Lastly, Donlon stated that it would be embarrassing if the family of the injured officer were provided false information. 496. Donlon issued a directive to ensure accurate and unified updates were provided to defendant Adams during field operations. This was designed to prevent the dissemination of unverified or conflicting information. 497. Defendants Madry and Shell stated that they updated defendant Adams when he called them directly. Donlon emphasized that this fragmented communication was problematic, especially since defendant Adams was also contacting others at the scene. 498. Donlon then stated to both defendants Madry and Shell that the NYPD would look extremely disorganized if several different NYPD employees were providing updates directly to defendant Adams that were incorrect, rather than getting information from those who were working closely with the hospital administration. 499. Despite Donlon reiterating the necessity of this basic emergency planning organizational necessity, defendants Madry and Shell simply failed to act, demonstrating an early and alarming pattern of insubordination and operational neglect. 500. At the following Monday's NYPD executive team meeting on September 16, 2024, Donlon's attempts to address these systemic failures were met with further evidence of profound incompetence. 501. It became shockingly apparent that the executive team, specifically defendants Madry and Shell, possessed no structured operational plan for Brookville Hospital, nor even a fundamental understanding of crisis management and emergency planning, not just for Brookville, but for any hospital facility responses, citywide. 502. This deficiency was not a minor oversight, but a gaping hole in preparedness for critical incidents involving an injured MOS, where standardized protocols for meeting areas, family assistance, traffic control, access restriction, communication, and media relations are paramount. 503. When Donlon directly questioned defendant Shell about an operational plan for Brookville Hospital, defendant Shell's cavalier and dismissive retort, "I think we had one, I will look for it, I'll dust it off," was not merely a sign of a lack of urgency, but a clear exhibition of gross incompetence, neglectful indifference, and dereliction of duty, and meant he had no intention of looking for the op. 504. True to form, and despite two subsequent direct requests from Donlon, defendant Shell demonstrated a stunning disinterest and an utter lack of an operational planning mindset. 505. Defendant Shell's continued insubordination was evident, as he willfully avoided addressing the issue and failed to produce any plan for Brookville Hospital. 506. Furthermore, defendant Shell displayed an appalling lack of basic delegation skills critical for an NYPD executive. Rather than assigning the task to ensure its completion, he chose indolence and defiance. 507. On 3 occasions thereafter, Donlon inquired about the whereabouts of the LP plans he requested without receiving the requested documents. 508. Defendant Shell, when asked for the plans by Donlon, had nothing to say. 509. Frustrated by this blatant insubordination and sloth behavior, Donlon bypassed defendant Shell and other NYPD executives and directly tasked 3 and 2 star chiefs to solicit operational plans from their precinct commanders. 510. This initiative, born out of necessity due to the leadership vacuum, yielded results weeks later after Donlon instructed defendant Shell to follow up Well-structured plans were submitted by select commanders, proving that competence existed within the ranks, even if absent at the top. Again, Donlon asked Defendant Madry where the operational plans for all the hospitals in the 5 boroughs are, as requested well over approximately 5 weeks ago. Defendant Madry just looked at Donlon and said he would look into this matter. 511. Donlon further directed Defendant Saraceno, at a later date, regarding the need for operational plans for all hospitals in the 5 boroughs. Within a couple of weeks, Defendant Saraceno furnished Donlon all the operational plans for all the hospitals in the 5 boroughs. Donlon advised Defendant Saraceno to ensure these vital plans were accessible precinct-wide via a shared computer drive. 512. However, indicative of the pervasive culture of inaction fostered by his superiors, this crucial step also saw no follow-up, leaving critical information siloed despite Donlon's clear mandate. 513. The consistent failures in communication and response planning, spearheaded by the insubordination, incompetence, and indolence of key executives. Like Defendants Madry and Shell, necessitated Donlon's urgent call for immediate action to establish a standardized operational framework. 514. In a move that highlighted his own commitment to collaboration, a stark contrast to the indolence he faced internally, Donlon personally provided copies of the gathered operational plans to the commissioners of the NYC, OEM, and FDNY. These plans provide measures to safeguard the MOS, first responders, NYC residents, and the above agencies, despite the internal resistance, apathy, and incompetence of the defendants. Defendant Shepard interferes with the police commissioner's security detail. 515. The police commissioner is assigned a dedicated security detail of approximately 15 to 20 members of the NYPD. While the security detail is established upon the PC's appointment, whoever is acting as the police commissioner retains full discretion over its composition. 516. Upon assuming his role as interim police commissioner, Donlon exercised this discretion by personally selecting and approving his security detail, consisting of 1 lieutenant, 2 sergeants, and approximately 15 detectives. 517. It was Donlon's explicit intention to meet with all members of the detail personally. 518. Shortly after Donlon assumed his post, unbeknownst to Donlon, Defendants Shepard and Saraceno called a meeting of Donlon's security detail. Donlon was not present for the meeting, nor did he authorize it. 520. At the meeting, Defendant Shepard made clear he was in charge, not Donlon, as the police commissioner of the NYPD. 521. At the meeting, Defendants Shepard and Saraceno threatened the approximately 15 members of service that they are not to follow the orders of Donlon. 522. Donlon is further undermined by Defendant Shepard, who stated, "PC Donlon is an interim and will be gone soon, but I will still be here," thereby positioning himself as the de facto authority figure. Per the meeting's attendees, Defendant Saraceno endorsed this statement. 523. Defendant Shepard thereafter directed personnel to bypass the office of the police commissioner entirely for matters including transfers, requests, or other administrative needs, instructing them to report directly to him instead, as though he was the police commissioner. 524. Even in the absence or disability of the police commissioner, no one, including a deputy police commissioner, had the power of making appointments and transfers. 525. Critically, Defendant Shepard purportedly threatened the assembled security team that any attempt to bring such matters to Donlon's attention would result in punitive transfers to undesirable assignments. 526. Defendants Shepard and Saraceno had held the meeting with Donlon's security detail without Donlon's knowledge or authorization, and now controlled the security detail through fear and intimidation. 527. Donlon was only informed of this unauthorized meeting after it had concluded. 528. Donlon immediately and repeatedly complained to Defendants Adams and Madry about the actions of the NYPD defendants herein, and was retaliated against as a result of his protected speech. It became quite clear and was truly pointless for Donlon to speak to Defendant Adams regarding Defendants Madry, Chell, Daughtry, Shepard, or the remaining defendants. 529. The deviation from the paramilitary structure is well documented. 530. This deliberate circumvention of established protocols necessary for security within the highest level of the NYPD, combined with Defendant Shepard's coercive directives and Defendant Saraceno's dismissive attitude, constituted a grave breach of professional conduct and insubordination. When Donlon did speak with Defendant Saraceno, he dismissed his concerns, asserting that police commissioners, PCs come and go and you are an interim, implying Donlon's authority was diminished due to his interim status. 531. Donlon asked Defendant Saraceno to expound on that statement, and he, Defendant Saraceno, could not elaborate any further. 532. This justification was not only inadequate, but profoundly disrespectful to the office of the police commissioner, the established security structure, and Donlon's need to have trusted and qualified individuals in these highly sensitive security positions. 533. Defendant Saraceno's rationale failed to address the core issue of the unauthorized meeting and appeared intended to deflect accountability, manipulation, and insubordination from Defendant Shepard. 534. In short and in reality, Donlon continued as police commissioner in name only, with no power to perform any of his designated job duties. 535. These actions actively undermined the integrity of the NYPD's chain of command and fostered an environment of intimidation within Donlon's security detail, and compromised the fundamental principles of leadership, chain of command, and accountability essential within the NYPD. 536. This situation warrants a formal investigation to address the improper exertion of influence and ensure adherence to professional ethics and departmental regulations, specifically as to whom powered the NYPD defendants to comfortably act so contemptuously and reprehensibly without accountability. 537. It is widely reported in the media that Commissioner Sewell left due to the many breakdowns in the paramilitary structure and lack of real power and authority. 538. Donlon attempted to address this significant breach of protocol, as detailed above, regarding the security detail with Defendant Adams and Defendant Madry, but was met with obstruction, contempt, and insubordination. 539. Defendant Shepard repeatedly failed to respond to Donlon's calls and deliberately avoided direct communication regarding the matter. He would just walk away when Donlon attempted to speak with him. Due to Donlon's lack of support from Defendants Adams and Madry, he had to tolerate this behavior, as complaining would not have and not change anything. 540. Shortly after Donlon was named Interim Police Commissioner, the FBI conducted a search of his residence. 541. The FBI confiscated decades-old documents, some over 30 years old, related to Donlon's law enforcement career. 542. Donlon cooperated fully in the investigation. 543. The FBI incident caused Donlon and his family to suffer severe embarrassment and humiliation. 544. Following the search, rumors were circulated that Donlon was going to step down as the interim police commissioner. These rumors reached Defendant Adams, who telephonically contacted Donlon regarding these rumors. Donlon stated that he had no intention of stepping down, unless, of course, Defendant Adams requested it. 545. Thereafter, Donlon chose his own NYPD employees to join the police commissioner's office, which was the historical practice within the agency. 546. Defendant Adams repeatedly failed to discipline the NYPD defendants herein, emboldening them to further violate Donlon's rights. 547. The repeated failure on the part of Defendant Adams to discipline the NYPD defendants herein, and/or allow Donlon to do so, is extreme, outrageous, and has far-reaching and incalculable consequences for the safety and security for the inhabitants of New York City. 548. Around this time, as a result of the false rumors being spread, a former NYPD police commissioner contacted Defendant Adams to inform him that Donlon should be replaced and that he had a candidate to replace him. The culture of corruption. How Donlon was sabotaged by a corrupt command staff enabled by Defendant Adams. 549. From the moment Donlon assumed his duties, Donlon was confronted by a deeply entrenched culture of corruption, insubordination, and sabotage within the NYPD's senior ranks. His efforts to support the hardworking, honest members of the department and instill a merit-based system to justify promotions were continuously thwarted by a clique of self-serving officials. 550. A sign of this systemic rot came from Defendant Marino. His official duties in the police commissioner's office were administrative, such as tasking others with requests and orders from the police commissioner, processing invoices, liaison with the chief of personnel, and handling routine matters. The above-cited duties were the protocol and procedures authorized by previous police commissioners. 551. Whilst Defendant Marino ostensibly exercised these duties and authorities, his true power lay in his control over processes and his willingness to operate opaquely, in a blatant breach of professional protocol. Defendant Marino deliberately concealed from Donlon that he possessed a rubber signature stamp bearing Donlon's full official signature. Every police commissioner has an official rubber signature stamp made upon assuming their duties. It was only through notification from a senior NYPD MOS that Donlon discovered that Defendant Marino was in possession of said rubber signature stamp and abused its usage to authorize a fraudulent and unmerited promotion of Defendant Shepard described below. 552. When Donlon confronted Defendant Marino, he offered a weak excuse that the stamp being utilized by administrative staff who had the rank such as Defendant Marino held was a long-standing practice to alleviate backlog. 553. In each of the promotional lists that were fraudulently altered by the individual defendants, had officers selected by Donlon removed from the promotional list and replaced with officers that were not approved by Donlon. On paper, Defendant Marino illegally stamped Donlon's name to the promotional lists to make it appear, falsely, that Donlon had approved the promotional lists. 554. Defendant Marino failed to even provide Donlon with a copy of the final list after they were falsified and fraudulently approved. 555. While Donlon understood this need and agreed to the procedure for efficiency, he demanded to review the process himself and any and all documents that Defendant Marino had utilized the signature stamp. After this review by Donlon, he agreed to the protocol. That said, the fact that Defendant Marino never advised Donlon beforehand that he had a copy of the signature stamp was disturbing. The initial deception was a clear red flag. Defendant Marino had demonstrated his allegiance was not to transparency and efficiency or his new superior, but to the established power structure created and maintained by the NYPD defendants and Defendant Adams. 556. Defendant Marino kept Donlon completely in the dark as to which members of service were being promoted and by whom. Defendant Marino allowed defendants Shepard and Madry to control the promotional lists and then fraudulently used Donlon's stamp to solidify the promotions. What resulted was a transfer of wealth in the millions of dollars at the hands of the defendants herein who falsified NYPD records to make it seem like Donlon had agreed to the promotional list when he had no idea who was being promoted or why. First, Donlon gains knowledge of the defendant's first RICO predicate felony and tells Defendant Adams, who does nothing. 557. Shortly after Donlon became aware of the misuse of his police commissioner rubber signature stamp, Donlon noticed to his surprise that Defendant Shepard began to wear a third star on his collar when dressed in uniform. This would mean that Defendant Shepard had been elevated from the rank of assistant chief to bureau chief. However, Donlon had never promoted or authorized the promotion of Defendant Shepard. Ergo, Defendant Shepard was fraudulently functioning as an NYPD bureau chief. 558. Promotions of NYPD employees can only be made by the police commissioner. 559. Defendant Shepard's fraudulently functioning as a bureau chief occurred after Donlon took over, in name only, as police commissioner. Again, Donlon did not promote Defendant Shepard to bureau chief. 560. Without Donlon's permission, Defendant Shepard obtained control of Donlon's police commissioner's signature stamp from Defendant Marino and fraudulently imprinted Donlon's signature onto a memorandum to promote himself to the rank of bureau chief. 561. Defendant Marino was the only person in the NYPD who had access to Donlon's commissioner's stamp. 562. Donlon confronted Defendant Shepard about the promotion because he, Donlon, did not sign any promotion memorandum with respect to Defendant Shepard, nor did Donlon authorize anyone to use his police commissioner's signature stamp onto any memorandum regarding promotions. 563. As a result of the lack of authorization, Defendant Shepard forged Donlon's signature. 564. Donlon asked Defendant Shepard, who authorized his promotion to bureau chief. 565. Defendant Shepard, in a vitriolic tone and arrogant manner, denied that he took Donlon's stamp to get promoted. Donlon advised Madry, and he did absolutely nothing in handling Shepard's self-imposed promotion. 566. Days later, Defendant Shepard, when asked by Donlon again who promoted him, advised that Defendant Adams was the one who promoted him to a 3-star chief. 567. Donlon then spoke in person with Defendants Adams and Madry over Defendant Shepard stealing his police commissioner's signature stamp and promoting himself to bureau chief. 568. Defendant Adams informed Donlon that he, Defendant Adams, did not authorize the promotions of Defendant Shepard. 569. Defendant Adams took no action to discipline Defendant Shepard following actual notice of Defendant Shepard's unlawfully egregious acts. 570. When Donlon returned to the police department from City Hall, he spoke with Defendant Madry, who confirmed that Defendant Shepard did not have any authorization to promote himself to the rank of bureau chief, but that he, Defendant Shepard, had done exactly that. 571. Defendant Madry also told Donlon that Defendant Adams did not promote Defendant Shepard. 572. Defendant Madry advised he would speak with Defendant Shepard over the incident and rescind the falsified promotion. 573. Donlon instructed Defendant Madry to report the matter to the Internal Affairs Bureau. 574. Upon information and belief, Defendant Madry failed to report the crimes to IAB, nor did he speak with Defendant Shepard. 575. After Donlon learned of Defendant Shepard's unlawful self-promotion, he confronted Defendant Marino, who was the only person who had access to the police commissioner's signature stamp. 576. It is unknown to Donlon whether Defendant Marino willingly gave Defendant Shepard the police commissioner's signature stamp or whether Defendant Shepard took it from the possession of Defendant Marino with his knowledge. 577. Donlon then confronted Defendant Shepard directly. 578. Defendant Shepard denied that he took Donlon's stamp, telling him, "I did not take your damn stamp." Hell no. 579. Donlon specifically ordered Defendant Shepard to stop wearing the third star on his collar, but he refused. 580. To Donlon, this fraudulent promotion by Defendant Shepard is stolen valor and is a crime. 581. It is also a slap in the face to every chief who earned their third star on merit. 582. It is unclear whether or not Defendant Shepard received increased compensation from the defendant's city following his fraudulent promotion, in addition to wearing the third star he did not earn. 583. Defendant Shepard was temporarily allowed to work as a bureau chief after he falsified documents and forged Donlon's signature to promote himself to that rank. This meant that Shepard would have received a higher salary from public monies than he was lawfully entitled to receive during the time that he was masquerading as a bureau chief. This is theft. This is a crime. This has never been resolved. 584. Defendant Shepard, at all times herein, was emboldened to act in an unlawful manner by Defendant Adams and inter alia the other NYPD defendants. 585. It would not be until Defendant Shepard threatened to kill Donlon in November 2024, specifically stating to Donlon, "I will fucking kill you," that Defendant Shepard would be demoted from his stolen bureau chief rank. Defendant Adams is indicted on corruption charges. 586. On September 25, 2024, Defendant Adams was indicted on federal criminal charges. 587. The indictment charged Defendant Adams with 1 count of conspiracy to defraud the United States, 1 count of wire fraud, 2 counts of soliciting campaign contributions from foreign nationals, and 1 count of soliciting and accepting a bribe. 588. Following the indictment, Defendant Adams refused to resign his position as New York City Mayor. 589. New York State Governor Kathy Hochul threatens to remove Defendant Adams from office as he refuses to resign. 590. Governor Kathy Hochul forced Defendant Adams to terminate several bad actors from his staff, which he previously refused. 591. Based on the order of New York State Governor Kathy Hochul, Tim Pearson is forced to resign on September 30th, 2024. 592. On October 7th, 2024, Philip Banks and Winnie Greco resigned from Defendant Adams's administration due to their respective pending criminal investigations. K. The NYPD Roosevelt Avenue Task Force is created as a result of a dream of Defendant Daughtry. 593. In October 2024, there was extensive news coverage regarding the crime-ridden areas surrounding Roosevelt Avenue in Corona, Queens. 594. Defendant Daughtry told Donlon that he proposed a task force to address all the quality of life issues in the Roosevelt Avenue area, in particular human trafficking, prostitution, illegal vendors. 595. He further explained that the task force would include the NYPD, Fire Department, NYS Environmental Protection Agency, Department of Sanitation, Office of Emergency Management, and the Queens District Attorney's Office. 596. Defendant Daughtry claimed to Donlon in his office that he conceived of the task force in a dream. 597. Defendant Daughtry was assigned by Defendants Adams and Madry to lead this task. 598. Donlon was not impressed with Defendant Daughtry, who had virtually no experience or proven track record supervising police operations, and who regularly belittled NYPD employees under his supervision. 599. On several occasions, while on Roosevelt Avenue and in other venues, Donlon was compelled to confront Defendant Daughtry about his mistreatment of all ranks of NYPD personnel. Defendant Daughtry was routinely rude and disrespectful to MOS in front of Donlon. Defendant Daughtry's response to Donlon was, "You have to speak with them that way." This response left no doubt as to why Defendant Daughtry had a reputation among MOS of being rude and disrespectful when addressing them. 600. It was clear to Donlon that Defendant Daughtry, as evidenced by his actions, lacked meaningful leadership experience and/or operational experience regarding major investigations or training. 601. In or around October 2024, the City of New York launched Operation Restore Roosevelt, a 90-day multi-agency initiative intended to address public safety and quality of life issues such as prostitution, illegal vending, and retail theft along Roosevelt Avenue in Queens. This was announced in a press conference conducted by Defendant Adams. 602. Despite its stated goals, the ORR task force was fundamentally flawed in its design and execution by deliberately excluding federal law enforcement partners. 603. Donlon repeatedly recommended and advised that the task force collaborate with federal agencies to address the serious and transnational nature of the criminal activity alleged to be occurring in the area, specifically the complaints of illegal weapons, drugs, and gang activities. With these recommendations, Donlon made certain to all the above NYPD defendants and the 3- and 2-star chiefs at Donlon's weekly meetings that he was not criticizing the abilities and capabilities of the NYPD. 604. However, history has shown working with federal agencies and other law enforcement agencies has been extremely successful targeting the above violent criminal activities and/or organizations. It should be noted that the NYPD is a partner in several successful task forces with federal, state, and other law enforcement and intelligence agencies. Again, the frustrating and debilitating factors with this OR initiative was that defendants Madry, Chell, and Daughtry, or for that matter Adams, have never been involved working on or with a task force comprised of federal law enforcement agencies. 605. As usual, the NYPD defendants, with their inexperienced, ineffective, and insubordinate efforts, refused to listen to anyone with experience in these investigations. Their collective response was that they always know better. Unfortunately, the men and women of the NYPD who dedicated their time and effort with this OR initiative, and the residents of the area, suffered. 606. Donlon's recommendations included a strategic intelligence sharing protocol. A. First, systematically collect identifying information from all individuals arrested, summoned, or otherwise identified during OR operations. B. Second, provide this data to federal agencies to be checked against their national and international databases. C. Third, this process would have effectively identified individuals wanted on federal warrants, or those linked to ongoing federal investigations involving narcotics trafficking, human trafficking, gang activity, and other serious crimes. This collaboration would have provided a significant strategic advantage. Federal prosecution for such offenses carries substantially stricter penalties than state or local charges, including mandatory minimum sentences, thereby offering a more effective deterrent and a more lasting solution to the area's chronic crime problems. For example, if convicted, the defendants would have to serve 85% of their sentence, as opposed to lesser imposed sentences by state and city courts. 608. Despite these clear strategic benefits, senior NYPD leadership, the collective NYPD defendants involved in the OR task force, expressly rejected any collaboration with federal agencies. 609. The approach formulated by the NYPD defendants proved to be a short-term reactive enforcement blitz driven by media attention and defendant Daughtry's personal zeal for publicity, rather than combating crime and gathering intelligence. 610. While OR focused on visible, low-level offenses, serious violent crime escalated. During this period, robberies along the Roosevelt Avenue corridor surged 44%, and assaults rose 46% compared to the prior year. This misalignment of resources occurred while local precinct staffing was simultaneously in decline, making any long-term success unsustainable. 611. Consequently, the operation failed to produce lasting results, although Adams showed impressive, questionable statistical accomplishments. As predicted by critics and reported in the media, upon the conclusion of the ORR, the same criminal activity, including open prostitution and illegal markets, promptly returned to Roosevelt Avenue, demonstrating the ineffectiveness of the collective defendants' chosen strategy. The abject incompetence of NYPD executive leadership, specifically defendants Madry, Chell, and Daughtry, all of whom, as always, had their incompetence enabled and supported by defendant Adams, was and remains detrimental to public safety. 612. Despite its stated goals, OR was fundamentally flawed in design and execution due to the deliberate exclusion of federal law enforcement partners, defendant Daughtry's arrogance, and the politicization of the NYPD drone program. 613. Despite public praise from Donlon following well-received demonstrations of the NYPD's drone technology, events attended by Defendant Adams and senior officials, Donlon privately harbored grave concerns about the program's leadership. While the public optics suggested innovation and collaboration, the internal reality was one of dysfunction, obstruction, and retaliation. 614. Donlon, a former member of the FBI's Senior Executive Service, which constitutes the top 1% of its FBI nationwide staffing, has a wealth of experience working, managing, and coordinating criminal, domestic international terrorism, and domestic international counterintelligence cases. Moreover, Donlon is acutely familiar with counterintelligence efforts utilizing aviation aerial surveillance relative to national security investigations. Donlon made multiple respectful overtures to Defendant Daughtry regarding this topic to ensure its success. 615. In light of Defendant Daughtry's many utterances to Donlon privately, publicly, and at meetings with executive NYPD personnel that Defendant Daughtry wanted to implement the latest cutting-edge technology. Donlon, at one of his Monday morning executive meetings, always attended by 3- and 2-star chiefs and other uniform ranks along with civilian personnel, proposed leveraging his national security contacts to connect the NYPD with law enforcement and intelligence agencies experts. These agencies and individuals were at the forefront of drone integration, usage, and other latest cutting-edge technology, as numerous times expressed by Daughtry. This was an offer rooted in collaboration and public safety against criminal and terrorism matters. Moreover, on a personal level, Donlon saw this as having the potential to foment a better working relationship with Defendant Daughtry. 616. Defendant Daughtry rebuffed these efforts not with substantive feedback, but with a flippant and egotistical dismissal. No thanks, we got it covered. His refusal to engage was emblematic of a toxic pattern, not only him, but by defendants Kinsella, Madry, Shell, and Shepard. Defendant Daughtry routinely rejected assistance from any individuals with superior qualifications in favor of preserving his own unearned authority. Donlon never could understand just who Defendant Daughtry was referring to when he said, "We got it covered." Any decisions regarding the technology and usage of drones would have ultimately been authorized by the Office of the Police Commissioner. 617. Again, no collaboration with the Office of Police Commissioner ever took place. When Donlon inquired of Defendant Daughtry to explain cutting-edge technology, Defendant Daughtry could never bring forth any example to Donlon. Donlon asked Defendant Daughtry if he was coordinating efforts or seeking technical expertise and support from NYPD, but the Technical Assistance Response Unit received no answer. TARU is an outstanding unit, which is equipped to provide sophisticated technical support and specialized investigative equipment, and also assist other cities, states, and many federal agencies. During Donlon's tenure with the JTTF, Donlon had the pleasure of working with TARU along with JTTF members on several occasions. TARU's history shows their capabilities utilizing drones with search and rescue cases, documentation of crime scenes, and many other services. Again, due to Donlon's imposed lack of authority, leadership, implementation, and experience on critical, crucial, and life-saving matters. By orders from Adams, Donlon was seen as just a figurehead, not to be respected or listened to regarding any police matter. 618. While serving as police commissioner, one of Donlon's main objective and concern was to focus on the safety of MOS and, of course, the safety of our NYC residents. However, with Adams' directives to Donlon and the defendants, Donlon was obviously left powerless, which was clearly seen by the MOS. Defendant Daughtry's position was protected not by merit or performance, but by a direct pipeline to defendants Madry and Adams. When challenged, Defendant Daughtry would run to his political benefactors, ensuring his mismanagement was never questioned, and his insubordination to Donlon or any police commissioner was rewarded. 619. Donlon found it quite transparent that Defendant Daughtry's disdain for him stemmed from personal envy and resentment over not being selected as police commissioner by Defendant Adams. Rather than rise above those emotions in service to the NYPD and our NYC residents, Defendant Daughtry allowed it to dictate his professional conduct, even when doing so placed public safety and operational success at risk. 620. After Donlon's tenure, reliable sources informed him that Defendant Adams privately admitted regret over not forcing Defendant Daughtry to cooperate and set aside his arrogance. By that point, however, the damage was done. 621. The drone program's potential was lost, and another opportunity for innovation was squandered. Yet another casualty of Defendant Adams's loyalty first, merit last approach to governance. This again demonstrated Adams's lack of administrative and operational skill. 622. This episode underscores a broader pattern. Qualified professionals offering constructive reform were sidelined or retaliated against, while incompetent loyalists were protected and promoted. The NYPD, under the collective defendants' direction, had become a place where good faith collaboration was treated as insubordination, and personal vendettas were allowed to sabotage public safety initiatives. This theme was echoed throughout the NYPD by every disheartened MOS who believed promotions were given based on merit. Contrary to their stated goals of reducing crime along the Roosevelt Avenue corridor, the defendants refused federal assistance through dereliction of duty. 623. As stated previously, Donlon had extensive experience with multi-agency law enforcement operations and contacted several federal law enforcement agencies about initiating a joint investigation with respect to OR 624. Defendants Kinsella, Madry, Schell, Daughtry, Shepard, and Gerber, through their incompetent and obstructionist leadership, deliberately undermined this effort by Donlon to ensure the success of OR 625. Donlon repeatedly recommended and advised the task force to collaborate with federal agencies to address the serious and transnational nature of the criminal activity in the area. 626. Donlon's recommendations included a strategic intelligence sharing protocol as stated above. Such collaboration, as Donlon emphasized, would have offered a significant strategic advantage. Federal prosecution for these offenses carried substantially stricter penalties, where defendants have to serve 85% of their imposed sentences than local charges, including mandatory minimum sentences, offering a more effective deterrent and lasting solution. 627. The individual defendants summarily rejected Donlon's recommendations. As a result, the residents and businesses along Roosevelt Avenue continued to face pervasive and escalating crime, including but not limited to the trafficking of illegal drugs and weapons, gang violence, prostitution, and harassment of store owners and pedestrians. 628. During an executive meeting in the commissioner's office, Donlon directly confronted defendant Daughtry about the inadequacy of the task force he had assembled. 629. Donlon requested the names of investigative subjects, meaning those questioned, detained, or arrested during OR, so they could be vetted through federal databases, emphasizing the importance of avoiding interference with ongoing federal investigations. 630. Donlon unequivocally stated that addressing violent crime, illegal weapons, and gang activity required immediate inclusion of federal law enforcement. 631. At a minimum, Donlon insisted that meaningful discussions with federal partners were necessary to explore joint efforts. Donlon stated clearly this would be a partnership between the NYPD and the respective federal agencies. 632. Donlon emphasized that interagency collaboration is a cornerstone of modern policing, especially in the post-9/11 era, as outlined in the 9/11 Commission Report. 633. Despite Donlon's consistent and forceful advocacy at weekly NYPD executive meetings, his recommendations were met, with obstruction by defendant Daughtry and deliberate resistance by defendants Madry, Schell, Shepard, and Gerber. 634. Donlon also demanded adherence to intelligence sharing principles. 635. He urged the NYPD defendants to compile and transmit to federal agencies the names of individuals arrested, detained, or credibly linked to weapon seizures and gang activity by the NYPD, not related solely to OR. 636. Donlon explained that this data was vital for federal agencies to cross-reference with their databases. 637. This process could identify suspects or weapons connected to active federal cases, leading to more productive enforcement through federal warrants and statutes. 638. These professional, evidence-based recommendations, crucial to public safety, were met with contempt and personal hostility. 639. Defendant Daughtry, in a display of arrogance and disregard for law enforcement norms, stated to Donlon and other attendees at the Monday executive meeting, "I don't like the feds," and defendant Schell also arrogantly stated in front of all the 3- and 2-star chiefs and other ranks, "Come on, the feds. Try getting them out of bed at 2 a.m. on a Saturday morning to come out and work with us." 640. This attitude epitomized defendant Daughtry's insular approach, which was endorsed and/or tolerated by the other individual NYPD defendants. It was also disheartening and embarrassing to hear the above ignorant statements from defendants Schell and Daughtry. 641. As a result, any meaningful progress with respect to OR was sabotaged. 642. Undeterred, Donlon continued to emphasize the benefits of federal collaboration at a few Monday morning meetings, explaining that it would support both the NYPD and the community. 643. The flippancy of the individual defendants towards the joint NYPD and federal task forces was extremely disparaging and hurtful. These comments further undermined the efforts of current and past officers and diminished their roles in fighting terrorism and stopping crime. 644. Defendant Gerber, a former U.S. federal prosecutor known as an assistant United States attorney, later falsely claimed after one of the Monday executive meetings, when asked by Donlon about inviting federal agencies to join the OR task force. I don't remember any conversation at this particular meeting or at any other Monday meetings about inviting the feds to join the OR task force. 645. This statement by defendant Gerber was knowingly false and intended to conceal the collective dereliction of duty by the NYPD defendants. 646. Donlon asked defendant Gerber, "Were you sleeping at this meeting and at other Monday meetings?" Astonishingly, Gerber had no response, and he stopped offering comments at future meetings. 647. Throughout Donlon's tenure, defendant Gerber displayed contempt, deception, and subversion. Donlon was shocked that defendant Gerber, a former assistant United States attorney, showed no interest in authorizing federal agencies, such as the U.S. Marshals, ATF, FBI, or DEA, to support OR. 648. This refusal undermined a major initiative and left Donlon baffled. 649. Donlon found it extremely disturbing that defendant Gerber, despite his prior experience as a federal prosecutor, resisted involving federal agencies in a high-profile initiative like OR. 650. His resistance wasn't strategic or legal, it was personal, rooted in ego and control. This behavior not only impeded interagency cooperation, but also increased risks to NYPD officers and the public. 651. Donlon made repeated attempts to address this issue, but defendant Gerber continued to act with insubordination and disregard for operational effectiveness. 652. This reinforced Donlon's belief that defendant Gerber was being dishonest. It was hard to comprehend, especially given defendant Gerber's background as a former AUSA, that he failed to understand the benefit of cooperating with federal authorities on OR. It remains unclear whether his actions were based on directives from defendant Adams or influenced by defendant Schell's earlier comments about not working with feds. 653. Or, as implemented under defendant Daughtry with support from Madry, Schell, Shepard, and Gerber, failed to meaningfully reduce crime, despite NYPD claims to the contrary. 654. Media reports and community members indicated that prostitution, drug activity, and gang presence quickly returned. One local leader even called for FBI and DEA involvement to address the worsening criminal activity. 655. Donlon identified a dangerously outdated mentality among the collective NYPD defendants, who erroneously believed that the NYPD could not or should not collaborate with federal agencies. 656. This view, rooted in misconceptions decades out of date, ignored essential strategies of modern law enforcement. 657. Their resistance to federal partnerships obstructed opportunities for coordinated investigations and enforcement. 658. This refusal squandered crucial intelligence opportunities and had a devastating effect on the Roosevelt Avenue community. N. The incompetence of Operation Restore Roosevelt Avenue results in failure. 659. Ultimately, OR, defectively conceived and incompetently executed, failed to reduce crime. Due to the collective NYPD defendants' willful neglect, the operation focused only on what can be deemed trivial offenses, while violent criminals continued operating with impunity, directly endangering the public. 660. As Donlon predicted, OR failed to produce lasting results, proving the strategy's ineffectiveness and exposing the incompetence of NYPD leadership, specifically defendants Madry, Schell, and Daughtry, all enabled by defendant Adams Kinsella, Madry, Schell, Daughtry, Shepard, Gerber, Saraceno, and Marino. Defendant Adams further solidifies Donlon's lack of authority as the defendants maneuver for control. 661. Defendant City, Adams, Kinsella, Madry, Schell, Daughtry, Shepard, Gerber, Saraceno, and Marino, through their direct conversations with defendant Adams, knew that Donlon was police commissioner strictly in name only, had no real power whatsoever, and ignored the orders of Donlon as police commissioner, interim or permanent. 662. Donlon was deeply disheartened by his complete lack of authority within the NYPD, rendering his position effectively ceremonial. 663. Donlon regularly tried to go through defendant Adams for assistance in dealing with these problematic employees, but was pointless. 664. Each time Donlon raised a concern with defendant Adams, he was further stripped of his authority and denied the ability To perform his job, as the individual NYPD defendants became increasingly emboldened by the ineffectiveness of Donlon's efforts. 665. Following a private meeting that Donlon had with Defendant Adams at City Hall, numerous individuals, including several placed in positions by Defendant Madry, visited Donlon's office to elicit information about the meeting. 666. The questions were led by Defendant Saraceno. 667. Shortly after the meeting, where Donlon did not disclose the circumstances of the meeting with Defendant Adams, Defendant Madry called Donlon to see if everything was okay. While this may seem minor to the casual observer, it was and is the sole discretion of the police commissioner to disseminate or not the private conversations with the mayor.